Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Hello, couch potatoes. Good morning, good morning, good morning. My computer was being this morning, so I apologize for being a little late, but I got it sorted out. I think. I hope. I hope. It's already been a morning. You know, those mornings where you're just like everything you do is going so slow, and then other things decide to happen as well. That's how my morning's been. That's how my morning's been. I hope the morning's been great for all of you guys. Good morning, Angie of Oz. Your new name that I'm going to try to say like that every time. Good morning. Good morning, Lady in Gray. Hope you're doing great as well. There's Teresia. Good morning, Teresia, babe. Hope you're doing great. It is Wednesday. I don't know about you guys, but this feels like the longest week ever. Maybe I'm just like, I don't know. It's getting close to being school time and fall and summer being over and just a lot. It's just a lot. Lady and Grace said, I overslept and it's raining. I need an arc over here. We had a very loud thunderstorm roll in last night at like midnight, 12:30. It was loud. I don't know if we really got any rain, but oof, that thunder was rumbling. So, oh my goodness. Teresa's canning homemade salsa while listening. Look at you being so productive. I love that. I love that. Hello, Michael Green Chili Chicken. Good morning, winos. Not yet, but yesterday was the lovely Elbow, Feet, and Eyes 13th anniversary. Yes, we put up with each other for that long. Somehow it doesn't seem that long, but also forever. But he showed, oh, that reminds me, I left some of my snacks in my bedroom. But look at these pretty flowers he got me yesterday. The lily didn't make it. But, oh, because my green screen. Anyway, he got me these beautiful flowers. He also came home with 6 bottles of wine and a whole bag of my candy snacks that are my favorites. So I was like, that's perfect. That's perfect. Today is your birthday, Teresia. Well, happy birthday to you. I'll make sure everybody tells you happy birthday all day. I don't sing. Sorry, I don't sing, but we will put your little it's your birthday on my banner today. How about that? Happy birthday to you, babe. I love that. He is good at picking out flowers. He is a keeper. I guess I'll keep him. Yeah, he's pretty. He is pretty sweet. So you guys, today we are finally wrapping up Stephen Lawson's trial, an unbelievably short trial. It's only 4 days total. And so today, though, today we get to have his mom on the stand, and then Steve takes the stand. And we've heard him talk on interrogation videos and grand jury testimony. I don't know how good of a witness or how good a job he's going to do on the stand. I feel like it's going to be something. So at least we know we're going to be entertained. Yes, everybody, as you're coming in, make sure you say happy birthday to the lovely Teresia. You're looking forward to the liar who lies. Yes. And then they close up with closing arguments. Then they do their verdict. Then the jury does their weird sentencing recommendation thing they do. And then we will fast forward to his actual sentencing by the judge that was just a few weeks ago. So it's kind of a long day today. As usual, it is Wednesday, and I have an appointment every Wednesday at noon. So I will disappear for like an hour, but don't worry, things will still be running while I'm away. I'm not really away. You guys just can't see me because it's a phone appointment. Well, telehealth appointment, whatever they're called. I don't know. So I will have to step away for an hour. Now, you guys, tomorrow, there's not going to be any more couch court for the rest of this week. Next week, I'm still playing around with dates because we are going to be on the lookout for Donna Adelson's trial to start. I am going to do kind of like who is Donna Adelson and why are we here? If you're not familiar, it's a whole family affair, another family conspiracy thing going on. And Donna is the mom whose trial is next. It's only supposed to be like 2 weeks, but it's very high profile. So they're spending like 3 days trying to pick out a jury because her son already had a trial and was found guilty, and he took the stand. Donna is also taking the stand, which again, love that for us. And so we'll be doing that through like the second week of September, but also tomorrow for my members, for our members only, I'm going to start recording a series that I'm doing, a multi-part series that'll be released in December. So members, you get a sneak peek to some of the story. I don't know how it's going to go. Who knows if it's what we even use for the final shows? I don't know. But I was like, you know what? Let's all hang out. You can see me make all the mistakes, probably burp a lot. I don't know. That happens. Tell me if it's like, oh, let's do a little bit more suspense. I don't know. We're just going to hang out for a few hours, see what happens. And then tomorrow night, 8 p.m. Eastern, True Crime and Wine Time. The lovely Cap'n is going to be my guest host for tomorrow night. And we're going to be telling the story of the Athens, Georgia murders. And it has some twists and turns. I had not heard of it before. And it is certainly not something I had expected the story, the direction the story went to. So I hope you all join us for that tomorrow, 8 p.m. right here. So yes, this will be our last couch court for this week, but don't worry, we are going to be spending plenty of time together very soon. Good morning, Sammy Sunshine. Hope you're doing well. Hope you're doing well, babe. Please, Miss Georgia, hear my cries and indict Wendy Adelson. Pretty please. I mean, maybe. I don't know. We'll see. This case has been going on for years. What is this trial? I want to say this is trial 4. It could be 3 because I can't remember if Katie had 2 trials or not. I don't remember, but it's been around in the news circuit for years now. Fascinating for sure. Burps and mispronounced words. Yes, because we're classy. Oh, and you guys, the lovely Buffy, she is so amazing and so talented. It blew my mind away. I told her kind of the direction I wanted to go for the show. Last night, she sends me an intro video that she did for the new series. And holy crap, it's amazing. Like it legit is like a TV documentary opening. So you'll get a sneak peek of that for our members too, because I'm going to show our members that. So I'm very excited about that. Good morning, Dave. Hope you're doing great. Good morning. Oh, the first jury hung. Yes, thank you. So we are on total 4 trials of the Adelson gang there. Oof, gosh. Buffy does rock. Buffy does rock. And I guess I'll share that with some other people later today. But anyway, so that's what we'll be doing tomorrow. So if you don't get to join us, remember, join us tomorrow night. We will be here. And now, you guys, let's get into this trial because we're going to be here for a while today. It's like 4.5, 5 hours or something like that. So let's go ahead and get that started. Oh, I am going to miss this judge a little bit. Oh, well, next Thursday, the 21st, Brooks and Joseph are supposed to be sentenced. So I have that on my calendar. I think it's going to be televised. And if so, we'll definitely be watching that. I doubt it's super long, but maybe. especially with Brooks. I'm sure her family's going to have some things to say. That's for sure. Okay, there's our little judge. There he is. And let's get going. We have to jump around through a bunch of different streams today, but for the most part, we get good video quality, so that's nice. That's I'm double fisting my coffee. I don't think I can have enough. It is one of those.
At this time, with the records, like all 15 jurors have returned to.
Oh, he's wearing a red shirt again today when he's supposed to take his stand.
Mr. Wolf, you ready to call your next witness? We are, Your Honor. Call your next witness. It's called Barbara Coulter. Barbara Coulter.
That here. Oh, I forgot my little banner.
And if you'll approach the bench, please. That's good, right there. If you'll raise your right hand for me, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? You'll have a seat right over there. Try to sit as close to the microphone as you can, and please answer all questions asked of you. Mr. Buckler, proceed when you're ready.
Thank you, Your Honor. Good morning, Ms. Coulter.
Good morning.
Can you state your full name for the record, please?
My name is Barbara Jane Coulter.
Okay, thank you. And I'm going to ask you to talk to the jury, okay?
Okay.
Ms. Coulter, what's your relationship with Mr. Lawson?
He's
Steve
my
Lawson?
son. He's one of my sons.
Okay, and that would make his son, Joseph Lawson, your grandson?
Correct.
And you understand the circumstances that Mr. Lawson's in today, don't you?
Yes, I do.
I've just got a few questions for you. Do you recall an occasion where you were watching a docu-series or TV show related to the disappearance of Crystal Rogers?
Yes.
You may have to speak up just a little.
Yes.
And who were you watching that with?
With Rebecca and Elizabeth, her daughter.
Okay, I'm going to ask you to clarify, who is Rebecca?
Rebecca Greer at the time was my daughter-in-law.
Okay, and was Rebecca Greer married to Steve?
At that one time, yes.
Okay. And you said Elizabeth Chester was there as well.
Correct.
You're on the
I'm going
banner.
to ask you the question directly. Did anything about this case come up in discussion between you and Elizabeth Chester?
She was discussing the case with her mother, but I was there.
Okay, and what did you hear Ms. Chester say?
She was talking about how Joey had been telling her this and this and this of things that had happened, and that at the end he said that if she told anybody or let anybody know what he told her, something bad could happen to her.
And this was what Joey had conveyed to Elizabeth Chester.
Correct.
Did Elizabeth ever say anything about things that Stephen Lawson said to her about this case?
No.
Now, Joey's your grandson, right?
Correct.
What kind of relationship does Joey Lawson have with Elizabeth Chester?
They are still in communication. So he still calls her, and I don't know if she's doing it now, but she was sending money for his books.
And this is while since he's been incarcerated as a result of this case.
Correct.
And what kind of relationship does she have with Steve?
She has disliked Stevie most all the time since she's known him because of stories that Joey had told her.
What about somebody named Stacy Kramer? You know that? Do you recognize that name?
And that was the girl that Stevie was dating from E-Town.
Okay, so you said Steve dated her. When did Steve date her?
He was living at my house. It would be 2019.
He was dating
2019.
Stacey?
So Steve Lawson was in a romantic relationship with Stacy Kramer as recently as 2019.
Correct.
Do you remember about how long that relationship lasted?
On and off, maybe 6 months, to my knowledge.
So when
They
she
may
was
have been
wearing
going
a
together before
wire
I
for
found out.
driving?
I figure around 6 months.
would it surprise you to know that Ms. Kramer testified that she was afraid of Steve Lawson as early as 2015?
I don't know why she'd be afraid of him, because he was about things, and so I don't know why she'd be scared of him.
Good morning,
And that
babe.
relationship, like you said, was in 2019.
Yes.
4 years removed from 2015.
Yes.
Well, look at that.
This
New
whole-
information. Did not know that.
A phone call was played between you and Mr. Lawson. Since you found out that Mr. Lawson was involved in this, and you recognize he's not hiding that, have you grilled him about this?
Before he went to jail, I did. I was angry. I was hurt. And I mean, he come to my house and I said, we got to talk. I said, I've told you boys your whole life, don't lie to me, no matter what you've done or how bad it is. Don't lie to me. And then, all of a sudden I find out, because he said the only thing he had done was go pick Joey up at the car, his son. And then I find out later it's a whole
Let me see,
different.
counsel at the bench.
Oh,
It would be hearsay, so what would be the exception to this testimony?
Was it offered for the truth of the matter asserted?
Well,
Sounds like it was.
yeah, I can just read the question. I'm not really asking what Mr. Lawson told us.
I was just necessarily.
So, Ms. Coulter, without going into what Mr. Lawson has told you, because that's hearsay, okay? I'm not asking you to hide the ball here, but there's rules of evidence that we have to follow, and that's why I'm not asking you to go into what Mr. Lawson told you, okay? I'm asking you if you have grilled Stephen Lawson about his involvement in this case,
Yes.
and you're his mother.
Yes.
And do you and Steve have a good relationship?
Yes.
Do you think he trusts you?
Yeah, I do.
And have you all ever had a bad relationship?
No.
mhm.
If I could have just one on Your Honor.
I mean, it doesn't sound like great, though.
Ms. Coulter, I just want to clarify on the phone call that you had to Steve at the jail. You know what phone call I'm talking about?
Yes, sir.
You were pretty terse with him, weren't you?
Yes, I was.
You used some profanity,
Yes, I did.
and that was because you were trying to get Steve to tell you the extent of it, right?
Correct.
Did Steve ever tell you? Well, I'm sorry. I'll withdraw the question. I think that's all, Your Honor. Reserve for redirect, please.
Certainly. Any cross.
She seems like a nice lady.
I'll be right there, Ms. Coulter. I got to put this thing on. Good morning, Ms. Coulter.
Good morning.
I want to say I'm sorry. I didn't want to be here doing this, okay? So I got to grab my notebook. I'll be right back.
Shame. Why is his feet making those noises? Is he wearing like those spurs on his shoes or something? What is that?
Ms. Coulter, you remember meeting me a
Yes.
couple weeks ago in the kitchen, right? We had a talk. And what you told me that day was the truth. Is that right?
Correct.
Yes, sir. You never, you've been very honest with me, and I appreciate that. You had told me that there was a morning where Steve had called you, right, or called Rebecca, and I think had you both on, I think you're on two-way or something. Does that sound right? Were you all on the phone?
No, because through the court system, only one can talk.
Oh, okay.
And then
Well, you and Rebecca had talked. Is that fair to say?
we had talked, yes.
Okay. And Steve had told you that he had agreed to move a car for Brooks' house, correct?
Correct,
Okay. And that Brooks had asked him to do so, and he agreed to do so, right?
correct.
Okay. And him and Joey actually moved the car, correct?
Correct.
Okay. And you told me that you got 3 kids, right?
I got four.
I'm sorry, 4. Okay. Four boys?
Four boys.
Bless you. And you told me that you'd gotten good at being able to tell when they're your mom, right? And you could tell when they were lying to you or not?
Yes,
Okay. And you went through each kid with me and told me how you knew each one was lying, right? One of them wouldn't say anything, right? The other one would look around and wouldn't look at you.
exactly.
I forgot what the third one
The other
was.
one would look at the floor. He'd never
Look at the
you.
floor. And then what did you say about Steve?
If you confront Stevie and you know that he's lied to you, then he gets irritable with you.
Okay. And does he just start talking about stuff?
He'll just talk about, if you've asked him a specific question, he will go to another subject to try to block you off.
Deflect.
And you told me, I knew for sure he was telling the truth about that, right?
Exactly.
Yes, ma'am. I don't have any further questions, Ms. Culper. Thank you.
I
Any
mean,
recourse?
moms are pretty good human lie detectors.
Ms. Coulter, during your conversations with the Commonwealth and law enforcement, have you ever conveyed to them that you had knowledge that Stephen Lawson killed Krista Rogers?
No,
Have you ever conveyed to them that Stephen Lawson had knowledge of what happened to Krista Rogers?
no.
That's all I have, Your Honor. Thank you.
Any recross?
Just one.
Just one question. What are you going to try to sneak in?
Did you convey it to us or me, really? It was just me and Rebecca, right? Talking in the
Yes.
kitchen, that you thought Steve knew more and hadn't told it?
I did it for a long time, yes.
Yes, ma'am. You told me that a couple of
Yes.
weeks ago, right?
Yeah.
Thank you very much.
Any further questions of this witness?
No, Your Honor.
Any questions from any jurors? May this witness be finally excused.
Yes, I have the defense, yes, Your Honor.
You're
I don't know
finally
why the
excused,
defense
ma'am. You
called
may go or
her.
stay, whatever
I'm
you
gonna be
wish to do.
honest.
Call your next witness.
Your Honor, the defense called Steve Lawson.
Mr. Lawson, if you'll come
There we go,
forward,
kiddo.
please.
Right? Mama knows best. Oh, look at her. Look at I'm sure it's
If you
so
could
hard
please
for
raise your
her.
right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
You'll have a seat right over there. Please answer all questions asked of you.
Oh boy. Buckle up.
Mr. Buckler, proceed when you're ready.
Thank you.
Oh,
Thank you, Your Honor.
Mr. Buckler's doing the questioning.
Mr. Lawson, state your full name for the record.
My name's Stephen Eugene Lawson.
Mr. Lawson, do you care if I refer to you as Steve?
Yes, but that's fine, sir.
Okay. That's how I've gotten to know you, Steve. Steve, where are you from?
Bardstown, or Nelson County area, or Chaplin.
Okay. Who are your family members?
Y'all just met my mother. I've got 3 other brothers, sister, and my father. I got my son, Joseph Lawson. Of course, y'all just heard his name. I had a few stepchildren I love very much. I won't mention their name. But that's pretty much the extent of my family.
Steve, what's your education level?
About the 10th grade, sir.
Okay, so you didn't graduate high
No,
school?
sir. No, sir.
What's your relationship with your son Joey like?
I don't really know how to say it. It's not very good. It's not well at all.
So you'd say your relationship with Joey's not good?
It's very poorly. Very.
Do you still love your son?
I will always love my son. I don't always like him, but I'll always love him.
Understood.
I'm sure that's
Now, what about somebody named
The
Elizabeth
same.
Chesser? What's your relationship to Miss Chesser?
She was my stepdaughter, which I just mentioned a while ago.
Okay, and that's because she's Rebecca Greer's daughter.
Yes, sir. She is.
Yes. And what's your relationship, or what was your relationship like with Elizabeth Chesser?
I loved her very much. I took up for her, even against her own mother, because she had a severe drug problem. And,
another
they were
birthday shout
butt
out. Birthday with
heads.
ya.
I still done my best to take up for her. She had a problem, so.
Do you have a grandchild?
Well,
Do you have a grandchild that's Elizabeth and
yes,
Joey's
I
child?
do. Yes, I do. We have
What's the grandchild's name?
Chloe Sharpay Chesser.
Have you ever helped taking care of Chloe?
She lived
Sharpay,
with me and my ex-wife for 3 years.
like the
Yes,
doll.
sir.
Helped take care of Chloe?
Took care of her every day for 3 years.
Did you say you and Elizabeth were butt heads?
Me and Elizabeth were butt heads. Me and her mom were butt heads
Don't worry about
over
the cord.
Elizabeth because she had a problem with drugs, and we both wanted to help, but we wanted to help in different ways. But I always tried to be there for her because she did have a problem.
And you know Elizabeth still today has a good relationship with Joey,
Yes, sir, I know this.
who's also indicted on this case and set the trial next month.
Yes, sir, he is.
But she has a bad relationship with you.
It seems like it has went downhill. Yes, very much so.
What about somebody named Stacy Cranmer?
As y'all heard a while ago, she was a ex-girlfriend of mine.
When did you guys date, Steve?
Didn't even know
In
that.
2019. I don't exactly know the dates, but in 2019.
You heard her testify that she was afraid of you in 2015.
Yes, and I didn't understand that comment. I still don't understand it right now.
Because you all were dating together as recently as 2019, right?
Yes, sir. Yes, sir.
Let's talk about Brooks South,
Interesting.
Okay, sir.
the elephant in the room. How did you get to know Brooks South?
Through my son.
Sorry?
Through Joey Lawson, my son.
Joey knew Brooks before you did?
He actually worked for him quite a bit, evidently.
You know about how long Joey had worked for Brooks
No,
before
sir.
you did?
No, sir. I can't answer that truthfully. No.
When did you meet Brooks South? Do you remember?
No, not actually. I know all I can tell you is my work was running short. I'm a drywall by trade and other construction. And he said, well, Dad, you know, Brooks has got some bobcat work that he needs done. I said, well, you go talk to him. If he says we can have it, then we'll go do it.
Yeah.
So, what we did.
Speaking of bobcat work, did you ever have an instance where you did a job poorly?
Oh, yeah, yes, sir, I did.
Okay. Tell the jury about that.
I don't know if y'all know what skimming grass off is. Most people know you just skim a layer of grass off and bring it down to dirt. Evidently, what is it called, HMO, Homeowners Association, at the golf course, got on him about some high, well, I said he had grass, it was real high. He said, well, will y'all skim the grass off? Yes, sir, we'll do that. He laid me out a platform, said go from here to here. Yes, sir, that's what I'll do. Well, evidently I went a little further, and it might have been my fault, maybe not. I've done a lot of drinking back then, I'm not gonna lie to you. So I evidently went a little too far and got in somebody's property and tore their property up. He come out there. Actually, the whole story is he come out there with Crystal. I don't think the baby's name. I'm not sure the baby's name. Can I have the baby's name, please? And him, he got out of the car and he was very angry with me. I'm not gonna lie. He convinced him to say some, got pretty rowdy with me. And I told him, I said, no, we can't do that around the baby. That's not cool. You want to holler and scream, just walk over here. We can holler and scream at each other. We're not going to do it around the baby.
You're talking about Brooks.
Yes, talking about Mr. Okay, yes, sir.
So, do you remember how recently that job was done?
How long ago has it been done?
Yeah.
I'm not sure.
You know how close, does you remember if it was close in time to 2015?
Oh, yeah, it was sometime in 2015, I would say, but I don't know exactly the date or nothing.
You admittedly botched a job mowing on, cutting grass for Mr. Howe as recently as 2015?
Yes, sir.
Okay.
Yes, sir.
How long had you worked for Mr. Howe as of July 2015?
I probably the whole time, you know, I helped him do a little. I didn't really do no framing. I just pushed the boards up. I'm not a track no framer. My son, he's a framer and everything. So I helped do what I could. My job mostly was doing a little drywall work, skimming grass, some easy stuff, just to be honest, to me.
You consider yourself a jack of all trades and a master of none?
Yes, sir, I really would.
Steve, tell the jury what happened in and around July 2015. Why we're here.
Oh, why we're here? Why I'm here sitting here? Yeah, yes, sir, I will. I'll tell you. There was actually somebody had fell through a ceiling on one of his previous properties. And I was doing bobcat work, as I just told y'all. And he said, well, I got a hole in one of my properties over here. You're a drywall man. What would it take to fix it? Well, I can't answer that till I see what's been done. So we all go over there.
There was a crack.
Joey, him, Brooks House, that is. There was another man, Charlie, somewhere in the vicinity. I don't know exactly where he was at, but he was there. We get over and he did ask about the hole. I think I told him $450, to be honest with you, what it would take it fixed. Him and his son was talking about a vehicle.
Steve, I think you can scoot your mouth a little bit closer to the microphone.
I'm sorry. Can y'all hear me over there? Thank you. And anyway, I told him about $450. My son and I was in the house with him, and he had said something about moving the car. Actually, he was talking to my son. I was a part of the conversation. I'm not lying about that.
Good morning, Pam. We sure
Well,
do.
I told you first I wasn't going to move it. That's
Just
on
in
record
time.
that I have said this, and I did anyway. So he said, would you move the car? Yes, sir, I will. Later on that evening, of course, I'm a drinker. I denied that. I went to the bar. I got to drinking. I don't remember if my son was actually with me at that point in time or not. But anyway, later on, my son come along, and he was wanting to get high. Another man named Charlie, like I just mentioned a while ago, he come up. They was both wanting to get high. I tossed him my keys to my car so you can't get high at the bar. We
So
had another
go
friend
get
that actually
high in a
owned this
car and
bar.
drive
I didn't
around.
want him to get hemmed up with them out there sticking a needle in your arm, just to be honest with you. So they drove off. The son come back. I never did see Charlie no more.
He's shooting
Where
up,
he come
man.
into, I do not know, and I won't elaborate on it because I don't know. So we was sitting there and we was doing some more drinking. I think actually he was outside smoking a joint, just to be honest. He come in and said, Daddy, we gotta move the car. Okay. Where he got the keys from or anything else, I do not know. All I know is he said, we're gonna go move the car. I'm pretty sure that I was driving my Nissan Maxima at the time. I take him up the road toward the golf course. I drop him off. I do like a little U-turn. I'm still drinking. I go out to Thompson Ridge. I was getting pretty drunk by that time. I didn't want to be in town, so I go out to the bar. I continue to drink. I'm not going to say if it was 10 minutes or if it was 30 minutes. I was drinking. If something was still in that area somewhere, I see the car pull up, and I'm like, this
No,
doesn't make sense.
It's YouTube being YouTube, Pam. We don't
I'll
know.
explain that to y'all.
We don't know what's happening.
This farm that
It's
I
not
was
you,
sitting
babe.
on belonged to a David Thompson and a Jeremy Thompson. And Jeremy Thompson, they're both dead. But he had a stealing problem. And my son had a stealing problem with him. And when it went past one point on that farm, past a certain point, that vehicle was getting stolen. It was that simple. There was other stuff out there that I had seen go across that line. That's why I didn't go past that line. I didn't want to know what was back there.
Okay.
I seen him going back that direction. I hollered, No disrespect to you young ladies. What the F are you doing? Why is that car up on this ridge? Mr. Thompson does not deserve that. You need to get it off of here. Well, of course, my son being who he is, he didn't really say much. I got a couple good cuss words, and this, that, and the other. But anyway, he drives back out. I get sort of a couple of good fingers out of him. Then I'm still sitting up there drinking. This was nothing unusual for me to do. I'm sitting up there and my phone rings. I'm like, okay, so I answered. I'm like, I don't know what time it was. It was late, probably around 11 o'clock. Might have been a little later than that. I don't know. I'm like, yeah, what's going on? Well, I'm broke down. I'm like, what do you mean you're broke down? Plain and simple, I'm broke down. Well, where are you at? I'm on the BG. Well, y'all might not know anything about the BG. It's a pretty good little stretch through BG. Well, that doesn't tell me anything. Well, I'm headed toward E-Town direction. Well, I can find you if you're headed toward E-Town. I'll just head toward E-Town, Elizabethtown, Kentucky. So I get to driving, actually, drinking, driving a little fast. Actually, I passed him up on the highway. So I made a little U-turn, come back, parked on the other side of the road. I got out, walked across the median. He was actually standing at the vehicle.
Because that makes sense.
I'm like, you broke down? I don't see nothing broke. Nothing. But he said he was broke down. I was like, well, okay. Well, what do you want to do? He said, well, we got to get out of here. Plain and simple. We got to go. My son always carried a little baseball bat, a little slugger. I don't know why. I gave it to him when he was a little kid. A security blanket is what I called it. He always packed that thing with him. Well, where's your bat at? Because he always had it. You can see it right there. It had a little golden hook on it that you could hang up. I seen it shining. I reached in there and I grabbed it. Will not lie to you. I pushed the seat back. I done that. I'm man enough to admit that because I done that. Did I go take him to get the car? Yes, I did. I'm man enough to admit that. Did I pick him up from that car? Yes, sir, I did. Young ladies and gentlemen, I did this. I will not deny that I did not do this to anybody. I did for a long time because I didn't want to man up and take the blame for that. When I should have. And I'm here today telling you, I'll take the blame for that. I don't want y'all to say that he's trying to get out of something. No, because I'm not. And that's just the facts of it. Go ahead, sir.
Steve,
Go ahead,
you recall
sir.
this, there's been testimony given about this conversation that you had with Brooks at the job site when Mr. Houck said something to the effect, I want her gone. You testified about that?
Yes, sir. I do remember this conversation. Yes, sir.
I want you to describe your recollection of that interaction.
Well, actually, I was walking up to another house in this, and he was parked in. He drove a big brown dually truck, and he waved for me to come over. I was like, yes, sir. Of course, I didn't know what he wanted at the time. It'd be hard to tell what he wanted. Him and Kristen Rogers was evidently had an argument or something. I don't know what happened. I wasn't there for all that. There was no phone conversation, nothing, but he was mad. He said, well, I just wish she was gone. I was like, what in the world are you talking about? I didn't quite answer it that way. I'm not going to use the cuss word. And he said, well, I just wish she was gone. I said, what are you talking about? He said, gone. I said, well, you mean gone? He said, yeah. I said, well, you're saying you want her deceased. And that is exactly the way I use it. That word, deceased. To me,
Okay,
I
sir.
don't pay much attention to people when they get mad and say stuff like that. And I'll explain that because I spent most of my life, my adult life, that has got me a divorce and everything else at a bar. I've heard it my whole life. Well, I'm going to kill that because he's over messing with another woman or vice versa. Or I've even seen stuff get so bad at the bar that men and women go saying this. I've watched them draw a gun on each other. To me, I don't pay any attention to pictures and stuff like that. I sort of laugh it off and go on. Well, I told him, I said, you got the wrong man. You got some of the meanest people in the world that works for you. Charlie being one of them. Y'all seen him up here the other day.
Charlie Gertley.
Charlie Gertley. Y'all seen him sitting right up here where I'm at today. I went and told Charlie exactly what I told him. I said, I told him he got the wrong man. He need to come talk to you. You're meaner than I am. Charlie laughed it off, and he'll tell you that he laughed it off. Ross is another one. He spent his time at the bars, the needle. He didn't admit on that one, but he didn't say that, but he was cocaine, this, that, and the other. But he done others. And that's fine. That's his business. He was like me. To me, when people say stuff like that, if I called every time to the law that I did here at, the city of Bardstown and Nelson County would never have no peace, because I'd have called them about 3 or 4 times a night at the bar. That's a promise.
After that conversation with Charlie, did you all ever talk about that again?
Not that I could ever recall. No. Not
Do
me.
you, I know it's been 10 years.
Yes, it's been a long time, sir.
But do you know how long before July 3rd, 2015 was that conversation with Charlie and that interaction with Mr. Howe?
I can't truly answer that on the day. Not to the day. I just can't, because I'd be lying to you if I did.
Would you say it was sometime in 2015?
What's that, sir?
Would you say it was sometime in 2015?
Yes, it's 2015, the year, yes.
Yeah.
Yes.
Mr. Houck, you said, asked you to move a car.
Yes, sir.
Mr. Houck asked you to help kill Crystal Rogers.
He never come out and said that he wanted me to help him kill Crystal Rogers. He never come out and said that.
Did he say anything to you about killing Crystal?
No, he did not. I used the term I did. You said gone, gone, gone. I said, in my book, that means you wanted deceased. He never said that.
No, I'm talking about whenever he ultimately finally asked you to move the car.
He never said nothing about killing nobody. No.
Yeah.
No, sir.
Did he tell you that Nick Houck was going to kill Crystal Rogers?
He never said nothing about his brother, as far as I know.
Did he tell you anything about Rosemary Houck?
No, sir.
So you're saying that one thing that he said to you ever was, will you move the car?
Basically, that's what he said.
Yeah, so what does
Well,
that
he did
mean?
say that. Ain't no basically to it.
Yeah. You mentioned earlier something about when you saw this car, Joey, driving it up on Thompson Hill.
Yes, sir.
You got angry.
Yes, sir, I did.
Told him to turn around and take it away.
And I'm not in them words, but yes, that'll work.
Now, what made you upset about that?
Because just like I told you, when Nick farm, he brought something to that farm, or Jeremy Thompson brought something to that farm. If it went to a certain point past the tree, it was point of no return. It was going to get stolen, ripped apart. I don't know how you would really chop is basically what I call it, sir. That's what I call it. And they was pretty active in doing that. And they was. I'm not going to lie for him. I mean, I know he's dead. He can't defend himself. And the son's in jail. He can still defend himself, but the truth is still the truth. That's what they was doing.
So you thought that Joey was going to take this car beyond the point of no return at Thompson Hill.
Yes, I did.
You didn't want that to be anything that Mr. Thompson would have to deal with.
No, because poor Mr. Thompson had dealt with his son, Jeremy, doing drugs, yada, 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 just like I had with Joey. And let's just be honest. It was Crystal's car. He done said it was Crystal's. So I know that you done said this was Crystal's car. So now she lives right here in this town, and you're bringing her vehicle up here. No, it's got to go. You ain't leaving a stolen vehicle sitting on this man's property. Because if it went past that point, it was stolen, trust me. And I'll tell you this.
See, you agree.
He
you've
sure
lied a lot
does
over the
stay
years?
honest
No.
and trust.
Would you agree
all
you've lied
that
a lot
whole
over the
lot.
years?
What?
Would you agree that you have lied?
Yes, sir. I'm sorry. Yes, sir, I have.
Let me get a little closer.
I apologize for that.
Do you agree you've lied a lot over the years?
Yes, sir.
Why is that?
Didn't want to man up. Plain and simple. Take the blame for what I just told you. I didn't want to take the blame. When I touched that car, I took my son to get that car, and I went to pick him up, and I moved that seat. I already committed what I call a crime. And evidently it has been, because I'm sitting here. I didn't want to man up and admit that I'd done that.
You know how many times you've talked to law enforcement since this case originated?
15, 20 times maybe, sir. I mean, that's just a guess.
Do you remember when you were indicted in this case?
No, sir. I don't.
Exactly, Michael.
Give me 1 second, Steve.
I apologize for that. No.
Ugh. My eye. You ever have your eye twitching like right underneath of it? So annoying. He is very polite, but I think he is a good bullshitter. A king of bullshitting, if you. That's what we've been told about him, and he talks like one.
Steve, do you remember the exact day that you were indicted for
It's so
tampering with
weird.
physical evidence?
No, sir, I do not.
If I showed you a copy of your indictment, would it help to refresh your memory?
Yes, sir. If you really would, sir. It's May of 24.
Talk to the mic, Steve.
May of 24th, 2023.
That's when you were indicted with tampering with physical evidence, right?
Yes, sir. What it says, sir.
Did you get locked up for that?
Oh,
No, sir.
no, the more you know. Who has me? I need some
Do you recall
chocolate.
why you didn't get locked up at that time?
I got chocolate.
That's to my knowledge, best that I can remember. I was cooperating with them. I said, this is what I had done, this, that, and the other, about the car.
Hey, on top.
And they said, well, as long as that's what you've done, then we'll let you back out on, I think it's called bond, ain't it?
Mhm.
And then you'll be able to stay out on bond. And it didn't work that way. Then turned around later on, I don't know exactly when, they took me, they went to the grand jury, I guess, with a sealed indictment on me and got me for, it's called complicity. Then I ended up getting locked up. And I think that was in December, maybe the 4th.
Would refresh your memory if you saw a copy of that?
Yes, I think it was December. Okay, I apologize. It is December the 6th.
Oh, well, I will
23.
write that down and look into it. Thank you, Dave.
So, Steve, you got indicted for tampering May 24th of 2023. Then you got indicted for conspiracy to murder December the 6th of 23.
Yes, sir.
You didn't get locked up in May the 24th of 23 because you were out on bond to cooperate with the Commonwealth, right?
Yes, sir. This is my understanding.
Was that based on the information you were providing?
Yes, that what I had done. Yes, sir. Yes, sir.
Steve, I'm going to show you a copy of this order.
Okay.
This is where your bond was actually amended to allow you to remain out of custody for the tampering, okay?
Okay.
You recognize that?
Yes, I have seen a copy of this in my paperwork, sir.
Okay. What does it say here?
I can't really see. My glasses are so scratched up, sir.
Okay.
I apologize.
It says continued cooperation with the Commonwealth.
Okay.
Do you remember that?
Yes, sir. That I do know.
And is that what you did, Steve?
I would say I tried to. Yes, sir.
In fact, you testified 2 more times at the grand jury
Yes, sir.
voluntarily, didn't you?
That's so.
Mean looking great.
Didn't plead the fifth for those 2 grand juries either, did you?
No, sir. Did not.
And did law enforcement continue to tell you that you needed to tell them more?
Best of my knowledge, yes.
What questions did they ask you specifically?
Well, I can't really recall all the questions.
Did they ask you if you knew where a body was?
Yes, sir. That has been asked on numerous occasions.
And what'd you say?
I have no clue.
And they asked you who killed her?
I think that has been asked, but I'm not going to swear to that for sure, but I think it has been.
Well, if I asked you the question, if you knew who killed her, what would your answer be?
Do I know? No, sir. I do not have a clue. I don't know that she is, so I can't answer that.
That's my next question. You know, obviously, we know what the presumption is that she's deceased. But
Yes, sir.
do you know for a fact if Crystal Rogers has
No,
today?
sir. I don't, and I will never say that for anyone.
Do you know what Brooks Howe did to her on
No,
July
sir.
3rd?
Don't know that he done anything to her. I can't say that.
You know if Nick Howe did anything to her that night?
Don't know that. Cannot say that.
Do you know if Rosemary Howe did anything to her?
Don't know that, and I will not say that.
I got one more here on.
Okay. They still don't explain like what to move
Steve,
a
just
car
a
was
couple
supposed
more
to mean. Wouldn't you ask
questions,
questions
sir.
like move it where? Where's that code
Going
for
back to Stacy Kramer, okay?
Yes, sir.
carrying the car?
Do you remember telling Stacy something to the effect of that you had to take care of a woman on meth with 5 children?
To help a woman. I didn't say take care of. That was her words.
Okay, what were you referring to? You remember that conversation?
Well, let me just explain it the best that I can.
Okay.
In my own words. I have woke up numerous occasions in my home after my wife was deceased. Wake up to children in my house that I had not a clue who they even was. Because my son had brought some woman in the middle of the night in his bedroom, and I'd wake up and there'd be children in my home. I didn't take it out on the children. I'd ask those fellas if they was hungry. I'd get up and pick them something to eat, then go wake him up and say, who are these people? Who are these children? Numerous times I've helped women that he has brought into the house with their children, give money to make sure they have food. Because evidently my son had, the woman wasn't going to do it because they was too busy sticking the stuff in their arm. I'm not going to make no excuses for him. I'm not going to make no excuses for me.
Steve, you know where Crystal Rogers' body's located?
No, sir, don't know that there is one.
Pardon?
I was gonna ask the answer.
Okay, I'll move on.
Sustain. Couldn't hear you.
Right?
Did you
Wow.
ever intend to promote or facilitate the murder of Crystal Rogers?
No, sir.
Did you ever agree to aid Brooks Howe in the planning of the murder of Crystal Rogers?
No, sir.
When you drove Joey down the Bluegrass Parkway, was there an agreement between you and Brooks Howe that Crystal Rogers would be murdered?
Never ever got said to me. So that's a no, sir.
Do you have any knowledge that Brooks Howe intended to kill Crystal Rogers?
No, sir.
When you drove Joey down the Bluegrass Parkway, did you think you were providing Brooks Howe with an opportunity to kill Crystal?
What do you mean when I drove Joey down the Bluegrass?
Well, let me rephrase that. When you went to go pick up Joey at the Bluegrass Parkway,
Okay, that's
when you dropped Joey off to pick up the keys, did you think that by doing that, you were giving Brooks Howe an opportunity to kill Crystal?
I've never drove Joey nowhere to pick up no keys.
Well, to pick up the car.
I drove him over the other side of the golf course to pick up the car. Then he broke down on Bluegrass Parkway, and I drove back down there to get him.
I know. I'm asking you for both. I'll start with. I'll split it up for you.
Okay.
Okay. So when you first take Joey to go get the car,
Okay.
at that point in time, did you think you were providing Brooks Howe with an opportunity to kill Crystal?
Well, no, I just moving a vehicle.
And when you went,
That's what I got told.
and when you went to go pick up Joey off of Bluegrass Parkway, did you think that was providing an opportunity for Brooks to kill
No,
Crystal?
sir. I was down there picking him up because he broke down, plain and simple.
Subject to redirect, Your Honor.
Any cross?
Yes.
I hope so. I got my family size nerd cluster. It's so good. I opened them last night. I shouldn't have done that. Well, on top of that, thank you so much for the super sticker. Thank you. Appreciate your support for more Nerds Dummy Club.
Can you get him something to drink?
So if they want to sponsor me, I will do that.
Miss Sowski, how are you
They're so
doing?
good. If you don't know what they are, they're these little
Mr. Lawson,
surrounded by nerds.
you told this jury
Oh, it's our Shane?
and a jury back in September of 23 that Brooks Houck asked you to move Crystal's car. Is that right?
This is correct, sir.
All right. And why did he want that car moved?
He never told me why he wanted.
What did you ask him?
No, sir.
You telling this jury that he asked you to move a car, Crystal's car, and you never asked him why or where?
Nope, never asked. Was I supposed to?
Yes, normal people do.
Your answer is you never asked him that.
That's exactly correct.
And then he told you told this grand jury in September of 23 that Brooks Houck told you, I need her gone.
He wanted her gone. I do
You
believe.
told the grand jury, I needed her gone.
Might just change his words there a little bit, but go ahead.
And you told him, I can't do it. Isn't that what you told him?
He's got the wrong man.
And what he was talking about is you got the wrong man because he wanted her murdered.
That ain't what I said. I said, he said he wanted her gone. I said, do you want her gone? No. He looked at me and I said, well, to me, that means deceased. That's exactly the way I said it.
Well, deceased in that instance was killing her.
Well, that's
No, but I'm just telling you what I said.
And then you went and talked to Charlie
I
Gurnley
went and told Mr. Gertley exactly what I said. Yes, sir. Just said that.
because you thought Gurnley might do that for her.
Didn't say that. I said I went and told Mr. Gertley what I said.
Well, you told Mr. Gurnley that Brooks Houck wanted his wife killed.
He said, and he laughed it off the same as I did. If you look at his statement, sir.
You knew at that moment that Brooks Houck wanted his wife killed.
No, sir. Did not know it. Will never say
He
it.
told you, I want her gone.
He said gone. I was the one that said deceased, not him.
You said, you told the grand jury that meant to you, he wanted her
To
dead.
me, that's what I said. Yes, sir. He never said that. And I won't say that he did.
And you moved the car.
Yes, sir. I know, sir. I said,
Where'd you move it to?
I just told you. Well, a while ago, I know you heard it. It went to Thompson Ridge. I didn't move it. The son moved it.
Well, what was the car being moved for?
Don't know. Didn't
You're
ask
telling
her.
this jury you didn't have any idea why they moved this car or this woman?
I just told you that a second ago, did I not? And I won't change my claim. I'll say it again. I don't know. I did not ask. And I'm not going to say that I did when I don't.
Well, you got something out of that movement, didn't you?
What did I get, sir?
You told the grand jury in September 23 that he promised you all of the drywall work that he had.
No, I asked for all of his work that he had, and that was previous before he ever asked me to move the vehicle.
Oh, he was going to give it to you without this arrangement.
I don't know
Is that
that
what you're telling
I
the
does
grand
not
jury?
know that he was or he wasn't. He never gave me no answer on that just quite yet.
We heard in your grand jury, you were asked, what did you get
I
for
said,
moving this car? And you told that grand jury, he promised to give me all this work.
he promised to give me,
Drywall.
but he never gave me none. He
I
never
didn't
gave
ask you
me.
whether you got it.
Okay.
I asked you whether you had got something in return for this house.
No,
For
no.
for
No,
moving
I
this
never got
car.
nothing. If I didn't get no work, I got nothing.
I didn't ask you whether you got nothing. I asked you, what did he promise you for moving that car?
You're not understanding, sir. I had asked him for the work previous.
I'm asking you whether you had told the grand jury that you got a promise from Brooks' house because you moved that
It
car.
wasn't for moving the car that I got promised anything. I had
So you
asked him
told-
his work previously.
So what you told the grand jury was lying?
No, that's not right. He was going to give me his work, but you're saying he gave me the work because I moved the car.
Oh, there was no connection.
Hey, you can call it coincidence, whatever. I had asked for the work previously.
All right, well, let's go forward. The car's up on Thompson Hill.
This is correct,
That's
sir.
where David Thompson used
This
it.
is correct, sir.
And you told Joy to get that car out of here, off the Thompson Hill.
Yes, sir.
that
Nothing
right?
quite words, but yes, sir.
Because you didn't want David Thompson to get hooked in this crime. Isn't that what you told the grand
That's
jury?
exactly what I said.
Because a crime was going on. And you were in the middle of that crime.
Well, the crime at that point in time was I thought the car was getting stolen.
He told you he wanted her dead.
You can go run that to the ground all you want. I'm trying to tell you, when it went past a certain point on that farm,
It's
that
what-
car was being stolen.
It's not something I made up. It's what you told the grand jury.
Said
It's
how?
what you told your mom.
What did I
You
tell
told
you?
your mom that he told you he wanted her dead.
No, there again. I said deceased. He never said them words. You keep saying he said it when he did not say that.
You're talking to the man. When you're talking to that man and he said, I want her deceased, you told the grand jury that meant to you that he wanted her dead.
You just said he said deceased. He did not say them words.
If I said that, I
Well, I'm not saying
apologize.
he didn't say
But
that.
you told the grand jury that when he told you those words, you knew that to be he wanted her
I
dead.
said that's the way I perceived it. That is what was said.
Well, you perceived it because you were talking to the man,
Well, yeah,
just like you and I are
just the
talking.
way I'm talking to you. Yes, sir. I agree. I'm
Now
talking
let's
to you.
let's go forward some more.
Yes, sir. Yes, sir.
What were you all supposed to do with that car?
Sir, I don't know. And I told everybody that. I told grand jury that. Take Joy, drop him off at the car. I go back to Thompson Ridge, continue to drink. I've never denied that.
You're telling this jury that he asked you to move the car, and you don't know where it was going to get moved
Nope,
or
I
what.
don't know.
Maybe it was just you thought it was going to be moved a
You
couple
know,
blocks down.
maybe Joey knows where it was supposed to go. I don't know. You can ask him. Because I don't. And I'm not going to say I do when I don't.
The car breaks down,
That's what Joey said, yes.
and this is around maybe late on July the 3rd.
I'm not sure, but I
All
just
right.
know it was dark. I can tell you that.
And Joey calls you,
This is correct.
and the phone call lasts 3 minutes or
I'm
so.
not sure. I just know
Well, it's in the record.
I just know he called.
All right.
Okay.
What were you talking during that 3 minutes after the car broke down on the bluegrass?
He told me the car broke down.
Well, that's about 12 seconds.
Well, I mean,
All right.
we're
I
like
want to
saying-
know what the 3 minutes you're talking on the
That's been a
phone.
long time.
Have you heard him try to say anything?
I don't
Takes
know.
forever.
All I know is where are you located? That's the first thing I'm going to ask. Where are you located at? I'm on Bluegrass Parkway. Where we're at, it's a long area. Where are you located at? Well, I'm headed toward E-Town. Okay, you're headed toward E-Town. How far? Are you at Line Station or where are you at? Well, of course, I ain't gonna lie to you. My son done been doing some dope. I didn't get no whole lot of answers out of him. Just headed toward E-Town. Guess what? I'll head that direction. So I did.
And you're telling this grand jury you don't know any more about that 3 minute phone
If I
call?
did, I would have just sit there and told you, sir.
All right, so you get
Been 10
there,
years ago. I can't answer some of these questions.
you get to the 14-mile mark, right?
Actually, I passed it up
And come back,
and come back on the other side of the road.
and then went to the car.
Yes, sir, I did.
Am I right?
You are correct.
Got inside the car,
What do
All
you mean?
right.
What do you mean got inside the car?
Crystal's car.
What do you mean I got inside the car?
Did you go get inside her car?
No, I wrenched my arm inside her car. I did not get in her car.
and moved the seat.
I told him I did second.
Is that right?
This is correct, sir.
You moved the seat so that it would appear that Crystal was the last person who was in that car.
Well, if it's her car, yes, I knew my son was just driving it. I'm not sure. I'm going to say 6'1".
It's always
Maybe
put
he is
fine.
like 6
Good time
foot
here.
one. I'm not for sure. I can't answer that. But I know she was shorter than he was.
You moved it because you wanted it to create this illusion
I've never done
that she was out there
No.
and the last person in the car.
Okay.
You didn't want Joy
I've never denied
implicated.
that. I never denied that. I haven't admitted that. I've never denied that.
You moved that seat up because that was part of the conspiracy that you had with Brooks to move that car and get it out of here.
You can say whatever you want to phrase it. That's not so.
Well, then what was the reason to move the
Just
car?
move the car. Now, I don't know. You have to
What
ask
reason
Brooks
was it to move her seat forward?
because my son was driving the car. He was 6'1". Is Crystal 6'1"?
I didn't know it was that
A
tall.
little bit later, after you moved that car, did you make a phone call to Brooks?
My son said, like, tell him the job is done. So I did just that. The car had been moved. No more, no less.
The car was sitting on the bluegrass.
That's where it broke down at, evidently. That's what I got told, that it broke down. Am I not right about that? Because according to the FBI, it had a flat tire with a piece of metal in it. So it was broken.
So you told them, is this what you're telling Jerry, that the car is done? We
Compared
moved
to
the
some of the
car.
days, yes.
Is that what you told
That's
him?
what my boy said. So
Ah.
I said, yeah, I'll tell him the car's done. It's moved.
On July the 8th,
I don't know about that.
4 or 5 days later,
Okay.
you get a phone call from Brooks House to you.
So I got a phone call from him.
You remember that phone
No,
call?
sir, I don't, but you can enlighten me, please.
He's in the Nelson County Sheriff's Office and he calls you.
Okay, I do remember this.
You remember this?
Yes, sir. Thank you.
All right. And he's asking you, what was that phone call about? Back on 1207 on July the 4th. He's asking, you remember what that was? Do you remember being asked that in that phone call?
I'm going to say yes. I think I do, but I'm not going to be just say for sure. How's that?
And you remember
It's the
telling
whole reason why
him
you're in jail, so
that the phone call was about
I think you would know.
getting a house for your stepdaughter, Lauren.
And I had called him about a house. Yes, sir, I did.
You told this grand jury on September the 20th of 1923 in the Nelson County grand jury
Okay.
that was a lie. That you and Brooks House had got together and made a plan to lie. To say that that phone call at 12:07 on the 4th of July was to help Lauren, your stepdaughter, get an apartment or a house. That was a set play between you and Brooks to deceive the Nelson County Sheriff's Office. You remember telling the grand jury that in September?
This is what I think I told him. I mean, I can't quote word for word, so don't hold me word for word.
I heard the words yesterday afternoon. Did you listen to that
I
at the
listened to
time?
some of it. I was doing other things too, but I didn't hear it all. No, sir, did not.
You want to hear that again?
Well, I don't need to hear it. I'll take you at your word.
All right, is that true? That you and Brooks decided
Go
to
ahead.
make a lie? To lie to the Nelson County Sheriff's Office about what that call was on 12:07.
Is that where Bowling
On
Green,
July
Kentucky is?
4th.
Because that's where they moved the trial.
Is that true?
Now, can I speak?
I don't remember what
Yeah.
county it was.
Thank you,
though.
sir. I had called him about an apartment for my daughter, by the way, thank you, and this can be proven. But here's what was said. I moved the vehicle. Well, I didn't move, my son did. I just assisted. And I told him, I said, the job is done. He said, well, you can use you to say that you called about an apartment after moving the car. And when you said it was done. Well, the job was done. Joyce had called, telling him the car was moved. So that's what I did. The car is moved. Job is done. He said, well, you can use for about calling me for an apartment so it don't look like that you done anything wrong. And that is the way it happened. But you're trying to say it happened a different way, and it didn't.
I'm telling you what you told the grand jury on
The same thing
September
that
the
I just
20th.
told you just then.
And
There's no
you
difference.
You told the grand jury on September the 20th
Go ahead.
of 23 that you and Brooks got together before this call and you planned a lie.
Go ahead.
You want to hear that? You want me to play this for you and the
You didn't have
jury?
to play nothing. I didn't told you that, sir. I told you that.
You're trying to tell this jury that it was not necessarily a lie. It was kind of a wiggle room or something.
You can call it however
That
you want
was
to.
a
You
lie.
can call it a white lie or a big lie, whatever.
It was a lie.
We'll just call it a lie, then that's the way it suits you.
And why did you and Brooks House decide to lie? Why would you need to lie?
Well, you got to ask him that.
Whoops.
Don't ask me.
You're the one that told the grand jury that you lied.
Well,
I'm
yeah,
asking you, why did you do that?
because I done moved the car. He said, just tell him to use this because you moved the car. Why? He said, I don't know. I don't know why he wants the car moved. Still don't know to this day why he wants it moved.
You're not answering my question.
Well,
I'm
evidently I'm not
asking you
understanding the
why,
question.
why did you decide to lie to the Nelson County Sheriff when Brooks called you and asked you what was the phone call at 12:07 about? You said it was about getting an apartment for
And
one.
that wasn't a lie. I
And
did
then,
call him
let
and
me
ask him
finish.
that.
And then later, before that rather, you told the grand jury that you and Brooks decided to put together this story, this lie.
I just explained it to you, sir. I'm not going to keep going over the same thing because I don't know what more you want from me. I gave you that answer.
I asked you, why did you lie?
So I can't answer it no more. I don't know what he wants me to say. Your Honor, I'm sorry. I don't.
No, he absolutely did not need to take a stand in this
I've answered
situation.
that. I said,
All right.
Bad
yeah.
idea.
That's your answer, that's your answer.
Talker.
I mean, I don't know what else you want me to say, sir. I'm trying to answer you here, but you just keep going over and over, and you're confusing me just by keep going over.
So you don't take the
I
stand.
apologize.
There's nothing confused about asking you why you would make a false story to the Nelson County grand jury about the call on 12:07.
Sir,
We never
you
have
keep
to.
saying that I did not ask him for an apartment for my daughter. And
There
I
are type
did
of
ask
cases
him.
where
Then he said,
probably
use that comment that I just said to you. That's the way you say, this is why you actually called me. Because I did ask him for an apartment for my daughter. You're saying that I did not do this when I did do this. I'm not.
I'm just talking that what the Nelson County, when you were the Nelson County grand jury, what you told them.
And I understand that, but you're saying that I did not say this as well, and I did. As far as I could recall.
When you called Brooks at 12:07,
Okay.
what did you tell him?
The job is done.
But the job wasn't done, was it?
I don't know. The car, I took Joy, let him move the car. The car got moved down there. So I don't know if the job is not. I don't know if it's supposed to be left there or anywhere. I don't know. You'll have
That's
to ask Joy that.
Well, you must have thought it was important to tell him.
No, I didn't think it was important. Joy thought it was important. He's the one that called tell him.
Who made the phone call to,
Did I just not say? My son said, mate, tell him the job is done. And that's what I did. Plain and simple.
You told Brooks Hawk the job was done when the car was abandoned on the
I
bluegrass?
don't know if they're supposed to be abandoned or not supposed to be abandoned. I don't know. You want me to give you an answer that I don't know? All I know is he said he was broke down there. Come and get him. That's what I did. Plain and simple.
Plain and simple, you guys.
I can't tell you
Plain and
what
simple.
Joy was thinking or what Brooks was thinking. I'm not a mind reader. I'm not that good.
That night, let's move on.
Okay, sir.
You went to and from the Thompson Hill.
Probably,
3 or 4 hours you're gone up on the hill.
maybe, yeah, I don't know.
Well, we went over this yesterday. You recall that on the location evidence?
Just because the location was there don't mean I was there. My phone could have just been there. We went over that too, I do believe.
Yesterday he went over it.
No, he's
And you
not.
admitted it was your phone. You had the phone that night.
And that's fine, but I've spent a lot of time on Thompson Ridge, 5-6 days at a time. What's that got to do with
You
it?
were up there 3 or 4 hours that morning.
Okay.
What were you doing up there?
Drinking. I've never denied that to anybody.
Well, at that time you knew you'd already heard Brooks House talk about wanting her gone, deceased.
Again, that's what I said.
He wanted you to move the car. You moved it.
Yes, I did. But he did not say that. I did.
He promised you for all the work, all the drywall work you wanted for moving that car.
Not for moving the car, no, sir.
All this was going on that night. You're up on Thompson Hill.
Yes, sir.
Is it raining?
I don't recall if it was raining or not. I'm not going to answer that because I don't know.
You leave, come back home, go back again.
Yes,
To Thompson
I'm
Hill.
4 or 5 times, truth be known.
What were you doing up there?
I'm going to repeat it again. Drinking.
You're telling this grand jury, this jury,
Yes, I'm telling you.
these individuals, that
Yes,
you're up there 4 hours in the morning of the 4th,
Yes, sir.
several more hours during the day,
Yes, sir.
coming back and forth.
Yes, sir.
I mean, it was the 4th of July.
And you're telling that has nothing to do with what happened to Crystal that night on July the 4th.
My drinking's got nothing to do with her. No, sir. I don't deny that anything.
All that movement that night, Joey's up there with you, isn't he?
At some point, yes,
Huh.
at some point, yes.
And you want this jury here to believe that your presence up there in those hills outside Cox's Creek, the early morning hours, had nothing to do with Crystal's disappearance at that same time? Is that what you're telling this
That's
jury? Is that
exactly
what you
what
want this jury to
Yes,
believe?
sir. I'm telling the jury that. And I won't never apologize for being up there drinking, that I was an alcoholic. I won't
Yeah,
apologize
no.
for that neither.
He doesn't seem like the kind of guy you can be like, listen, don't take, it's a bad idea, right? His lawyers probably told him that. And he was like, no, I got it. I'm going to be telling the whole truth. It doesn't even matter. Just like all the times he talked to the cops about his lawyer.
Disappears on July the 3rd.
That's what y'all keep
The
saying.
police talk to you because they see the phone call you made.
I say this is correct, sir.
You were here yesterday when the FBI special agent, Mike Schaefer, interviewed you.
I know Mr. Schaefer, yes.
And he was interviewing you because he wanted to know information that you had.
Not sure why, but go ahead.
And he asked you, did you travel up, come out of your house, travel up the bluegrass to where the 14-mile marker is, where Crystal's car was abandoned?
I'm not sure.
And you said you were in the house. You never left at all.
Sir, have
You were
I,
drinking and you didn't leave the house that night.
have I not admitted to these people at the jury that I was at the 14-mile marker time and time again? That was our open statement that I had been down.
I'm asking if you, but when asked by the FBI,
And I've
you
answered that
lied.
question. I said I did not want to man up. Have I not told the jury that?
So you
on
agree you
15?
lied?
Did I not tell y'all that a while ago, jury? That I sit there, did not want
What
to
does he
man
expect
up
them to do? Just
and own up to what I've done.
yeah.
You can beat that till it's like a dead horse. It doesn't make no difference. I have told these people that I have done this crime.
You lied
I lied about it. Yes, sir.
to
I've
protect
told that.
yourself. Am I right?
Yeah, I did not man up there again. I can say it till I'm
And
blue.
you lied to protect Brooke House.
I'm not. I lied to protect no Brook House in a day in my life.
By
Maybe
the
to
time,
protect my son, but never no Brook House. Believe that one.
by August 6th of 2020, Mr. Lawson,
Go ahead, sir.
she has been missing for over 5 years.
I'm not for sure. I'll have to take you at your word on that.
And on August 6th of 2020, as I said, you were asked numerous questions, trying to find out what happened to this young woman.
Still don't know what happened to her, and I can't answer that.
And you knew at that time, though you didn't tell Mike Schaefer, that Brooks House had told you
Told me what?
to your face
Told me what, sir?
that he wanted her gone.
That's what he said. Yes, sir.
And you believed that because you went to Gurdley and asked him,
I told Gertley what he had
take care of
said.
this for me.
I didn't tell Gertley to take care of that for me. No, sir.
In so many words.
No,
Will you do the
you
killing?
you are putting stuff into my mouth that I did not say.
Stop. I'll sustain the objection. Tell you what, I think the jury probably needs a break here. We've been going since 8:30 this morning, so what I'm going to do is take a 10-minute recess. We'll make it 15-minute recess. Ladies and gentlemen, the same admonition is still
I'm gonna need them to get in this lawyer fight too before I have to step away. I'm really mad if I
If
missed it.
anybody attempts to discuss this case with you, I need for you to immediately report that to me. If you're not able to make up your mind about this case until you've heard all the evidence, you receive instructions from the court, and you've gone to the jury room to deliberate and consider what your fellow jurors have to say about the case. We'll take a
Chat
15-minute
is
break.
very
Go
funny.
from there.
I hope so. Let's just zoom in while they leave. How about that?
Recess.
All right. They go to recess. Blah 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 blah.
That
Whoop.
interchange.
Let's see. There we go. That must have been from when I was trying to track the time yesterday. There we go. No music, but thank you. Closed caption. Let's go.
Everyone may be seated. Counsel, waive the call.
Yes, sir.
Mr. Lawson, you're still under oath, okay?
Yes, sir, Your Honor.
May I go?
Yes, you may proceed.
Russ, I think I stepped on your answers, and I apologize. Both of us do a lot of talking, so let me go back for a
we're
couple of
friends.
points. I'm getting rounding out here, so let me go over a couple of things I think they're important. I think you just told the jury, and it may have been one of my answers, or it may have been with my colleague here, Zach, that you moved the car seat up
Don't remember if it was up or back. I can't say.
Upper, well, you moved it up because she's shorter
Oh, okay.
than Joy.
Fair enough.
Because
It'll be the
the
last
car was what, stolen?
day
Well, if
for
it
this
goes
truck.
past that
So
point, like I said on Thompson Ridge, it was pretty much going
it's
to
like
be
verdict day for
stolen,
them.
sir.
So everybody will be there.
Well, it wasn't stolen. Joe Brooks asked you to take that car and move it.
He asked to move it. I don't
I'm
know.
also
where it's
surprised
going
that
to be.
Shane
I didn't
didn't
ask you that.
Okay, well,
So-
I'm just saying
question
There
him.
was no stolen vehicle. He gave you permission.
he gave. But he didn't give, I don't know where we're supposed to go. I just go come on Thompson Ridge, and after it comes past certain point on Thompson Ridge, it's pointing over turns, all I can tell you.
Well, when it gets down, it gets off of Thompson Hill
So I
Road.
told him.
You tell the jury that.
Yep, I
All
told him.
right, and it's abandoned at the mile 14 marker on the Bluegrass Parkway.
This is correct, sir.
That's when you move the seat forward.
Never denied that, sir.
All right, and you moved the seat forward because you wanted to create the illusion that this young lady was the last one in that car.
Never denied that,
All
sir.
right. And if you don't deny that, all right, then why would you move the seat up? And why would you be concerned with making that illusion that Crystal was the last person in the car?
I told you already. I've answered that question.
What is
already.
that?
I told you my son was driving that car. He's 6 foot tall.
I know, what I'm asking you is not what Joey was doing. I'm asking you about why you moved that car seat up.
I've explained that
I
already.
mean,
Why did you do it?
But I told you because I didn't want to get Joey hemmed up that he was still in that car. He took it to Thompson Ridge. That meant that car was going to get stolen no matter how you look at it. You don't know that because you wasn't up there.
know
You
her
don't understand
at all.
that, but I do understand that.
Or Brooks really
It
either.
wasn't up there. It was on Bluegrass Parkway.
But where did it come first, sir? Thompson Ridge. I told him to get that car off of there.
The truth is, you wanted to leave the impression to the police, to the Nelson County Sheriff's Office, that woman was the last person driving that car. That's why it was moved up
You
there.
can say
Had nothing to do with-
whatever you want to. I'm telling you what I did. I can't tell you no more, no less.
Now, when you went to that car, did you see any items in it?
I told 10 times. Somebody kept saying there was a person, everything. I've never seen anything. I tell you what caught my eye, and I'll tell you again what caught my eye. The door was open. There was no dome light on. That is something that caught my eye because when the door's open, what's supposed to be a dome light in a vehicle?
Now, you were here when Detective Snow
What a weird thing to
testified here a
remember.
couple days ago.
Yes, I'm sure.
And when he got to that car, abandoned on the Bluegrass Parkway, some of Crystal's belongings were on that seat.
That's what the young
Her
man
cell phone,
That's what he said.
her purse,
That is exactly what he said.
and the keys in the ignition.
Actually, I seen the picture of it.
You know how those items got there?
Yes, sir. And like I told you, what caught my eye was no dome light. It's 12 o'clock at night. It's dark. How am I supposed to see anything without a dome light, sir?
What, you don't know whether those items were there or not?
No, sir, I don't.
Okay, all right.
And I'll
I'm not, that's,
I just say I can't say it when I don't know it.
you don't know if they were there, and that's fine. I'm gonna go back to one of the questions I had. And I think I was stepping on your answer, so let me go back
Okay, sir.
to the interview you had with the special agent Mike Schaefer on August the 6th of 2020. You remember that interview?
Not really, but you can.
What, did you listen to the testimony, to the recordings of your
Yeah, some here and
conversations?
there.
All right.
Sometimes I block
All
some
right.
out a little bit. Sorry.
Well, my point at the time was you made repeated lies during that interview. You agree with me?
And I've done said that I did.
All right.
What more do you want me to say about that one?
Well, my question is, if you did not have an active role in this conspiracy to kill this young woman, why would you lie to the FBI? Why not help the FBI? You didn't kill this woman, as you told the jury.
Yeah, and y'all.
You asked Jack, asked you that question, and you said, no, I didn't kill her.
All right, now, and I'm going to ask you something. You keep saying.
You can't ask me a question.
Okay, well, I'm going to comment on what you said in my answer. Y'all keep saying, kill this lady. Is she dead? That's what I want to know. Is she? Because y'all keep using this term. Is she dead?
Sir,
All right, now you finished your
come on.
words. Go back to what I'm asking you. All right? I asked you why you lied repeatedly to the FBI agent 5 years after she's gone.
I answered that question a while ago, sir.
Why did you lie?
Implicated in moving this vehicle. I have answered that. I don't know how many more.
You lied to the FBI because of what?
Do you want me to repeat it again?
Yes.
I'll to the jury. Did not want to man up about moving the vehicle. I can't answer it no plainer. I've answered it time and time again for y'all.
You lied.
You need to phrase it any way you want to. It's not going to change.
Let me remind you. You lied when you told that agent repeatedly, okay,
We've come to this.
that you were in your house
To be honest, I
all night,
was
never
prosecutor.
moved. You were drinking. You don't
Thank
drive. You
over and
don't
over
go
again.
anywhere. Why would you lie about where you were
Thing I told him
that night when Crystal's missing?
First thing I told him, and I don't know if it's on record or not, but I'm going to tell it now. I drank so much back then, I don't even keep track of days. I still don't keep track of days, and I don't drink anymore.
Okay.
But
Mr. Lawson, isn't it true that you and I agree on at least some of these truths?
yes, sir.
That the reason why you lied to the FBI about where you were on the evening hours of July the 3rd and into the 4th,
Okay.
the reason why you lied and told that agent I was in the house, I never left, is because you were out there that night involved in the killing of this young woman.
First thing again, that's a lie on your part. You should
Answer the question.
No, sir, that is not true.
All right, then you can say no.
That's fine.
You lied about your whereabouts that night. You were driving up to Thompson Hill, as we pointed out 3 or 4 times,
Didn't say that.
and you're saying that's a coincidence?
Drove up there all the time like that. Is that a coincidence?
You were up there for 4.5 hours that morning,
Don't disagree.
and you're saying that has nothing to do with the disappearance of that young lady.
You're exactly
That
right.
that's just a coincidence.
Yes, sir. You can take it however you choose to, sir.
That's just a coincidence that her car's moved, she disappears, and you're up on Thompson Hill for 4.5 hours in rain.
I don't know.
That's
that
what
it-
you're telling
I
this
don't know that
jury?
it was raining. I'm not gonna say that because I don't know. But yeah, I went up there on several occasions in my lifetime like that, and I won't deny that neither. And like I told y'all, I was a raging alcoholic. I went up there to drink constantly. I won't apologize for being an alcoholic. I'm not. I'm recovered.
There's no questions on the floor. I'll get you another question if you
Talking
want.
to the jury.
Because we're besties now. He's not doing himself any favors, though this prosecutor is kind of annoying, I'll be honest. He's going frustrating. Like, we get it, he's a liar who lies. We get it.
You've been in this trial and you've heard that Crystal Rogers disappeared sometime on evening hours of July the 3rd of 2015. So again, I want to ask you,
Wow, indeed.
and I'm asking for the truth. It's not a coincidence. That you and Joey, that same evening, moved her car. And that happened, didn't it?
Never denied that, sir.
And during that same evening, her car is abandoned.
Don't deny that, sir.
And it was taken because Brooks House wanted that car gone. Isn't that true?
He said he wanted it moved. That's true.
I'm talking about like, it's not like moving the car down the street. I'm talking about he wanted it gone, didn't he?
He said move the car. He didn't say why. He said he wanted the car moved, move the car. That's all I can tell you. We've done went over this.
And you brought the car back and brought Joey back from the abandoned car. Is that right?
This is correct, sir.
And then a little later, you call Brooks. And you're
It's
at
important.
12:07
I said it's important.
that morning. You remember that?
Yeah, Joyce said call Brooks down, the job done.
And you told this jury here that you told them what, the job's done or the car's moved?
It was something like it, job done, car moved, whatever. It's the same difference, I guess.
What you told Brooks, truthfully, is the car is abandoned.
No, I don't think I said that, sir.
It was abandoned.
I didn't say that it wasn't. I don't think I said that.
And then a little later, you're out, as I pointed out, at Thompson Hill,
Yes.
sometime 4 or 5 hours that night. All right?
Don't disagree.
And you're saying those 4 or 5 hours that you're out there, you and Joey, middle of the night, raining,
Don't know that. So,
had nothing to do with her disappearance.
no,
That's what you want us to
you
believe?
can believe whatever you want to, sir, but that's the facts. Because on an average basis, I was out there a bunch of times out there drinking like that. So,
You lied to the FBI
we undecided that.
because you were involved, participated, was a conspirator in this young woman's disappearance. Isn't that why you lied repeatedly to FBI?
No, sir.
Lied to Jon Snow?
No, sir.
It was to cover up your responsibility for the murder of this young woman. Isn't that the truth?
No, that's not true, but you got a right to your opinion, sir.
That's all I had. Thank you, Judge.
Any redirect?
Just one question, Your Honor. Sorry, two questions, Your Honor.
That's right. Yes, sir.
Mr. Lawson,
Yes, sir.
Steve, are you aware that there was a search warrant executed on the Thompson Hill property?
Yes, sir, I am.
You're aware that nothing was discovered?
Yes, sir, I'm aware.
Okay. Steve, is there anything
Glad we can all
else
make you
I
laugh.
have not asked you that you think these jurors should know?
Not that I know of, but if you can ask me anything you choose.
That's all I have, Your Honor. Thank you.
Anything else in this witness?
No, that's all, Judge.
Any questions from any jurors? Let me see counsel at the bench.
Oh, please let this be when they get into it, because I got to leave in like 2 minutes.
Oh, yeah.
Ow.
This has certainly been an interesting one. Yes, sir. You're welcome. This has certainly been an interesting one. These are the questions that the juror wants to ask. What is Thompson Ridge? The next question is the question mark. dead person's farm, question mark, owned by who, and why are they there? This one here wants to know, why didn't you change the tire instead of leaving the vehicle? So, those are all municipal questions.
What was the first one? Are you going to ask it as written, or it's dead person farm?
What is Thompson? I'll just ask the first one. What is Thompson Ridge? Because they don't know what that is. If they're asking, is it a dead person's farm? But owned by who? I think it's a fair question. But
that dead person's farm is kind of.
So I'll go with, what is Thompson Ridge? Owned by who? Probably want to know why they're there. He's told them he's been drinking. How many times there's?
Why are they there? Okay.
Yeah.
Sure.
All right. Thank you. Fran. All right, I have a couple questions from the jurors. First question here is, why didn't you change the tire instead of leaving the vehicle?
I didn't know. He said it was broke down. He never told me what was broke down. He just said it was time to get out of there. So that's what I did. I didn't know till up here that the metal was even in the tire.
Next question is, what is Thompson Ridge?
It's just a farm. It's just a big farm.
And who is it owned by?
Mr. David Thompson. Now he is deceased, and his son is also deceased. So I don't know who it belongs to now.
What if that's like
And
the biggest word
question,
he knows?
Why are they there? Why are they there? Is the last question.
Me, my son, and Jeremy Thompson was good friends. That's how I met him. I done a lot of drinking, and he used, Mr. Old Man, Mr. Thompson, used to say, if you're going to drink, come out to the farm and drink. At least you can't get in no trouble. If you're out here sitting up here, you're not getting a DUI or nothing. So I would sit up here sometimes for
But then he was
days on end
driving
and get
around
drunk.
afterwards. That doesn't make any
Like
sense.
I told y'all, I was a raging alcoholic. I can't change that, who I was then. I'm not that now.
Guess maybe better than being at a bar.
But it's better than being out here running up and down the road, hurting somebody if I'm dog drunk.
Dog drunk.
Based upon the questions, okay, I've got another question.
What does that even mean?
This is counsel at the bench.
Oh boy.
First question is, when drinking, what is being drank? Next question, how much, the last word's consumed, how much, I don't know what that word is.
How much per hour consumed?
How much per hour consumed? Would this not keep you from driving? He's already alluded to that, and that's that. Why at bar drinking instead of home?
We're okay with that.
Driving the skid steer around all the time. Okay.
Have some more questions from the jurors.
Yes, sir, Your Honor.
When drinking, what is being drank?
What did I drink? I was a big Jim Beam drinker.
Oh, Jesus. And he's drinking
How
whiskey?
much per hour consumed?
On the average, like I said, I was a raging alcoholic. I would drink probably half a gallon a day.
Half a gallon. Oof, sir.
Would this
Wow.
not keep you from driving?
What's that?
Would this not keep you from driving?
I have drank and drive. I've done it. I'm not proud of it, but I have done it. But like I said, that's why he said come out there and sit on the farm and drink, and I didn't have to drive.
Those are the questions. Any redirect based upon?
That's
I guess
a-
Charles would
yeah,
think about
right?
Any redirect
That's
based upon
friggin-
the jurors' questions?
No, Your Honor, thank you.
Anything from the
Feels like
council?
he's even
Quick question.
here,
How,
really.
Mr. Lawson, you can't see me way over here, but how large an area is this Thompson Hill, Thompson Ridge?
They never
How
found
big is the
anything.
farm?
Yes.
Actually, sir, I don't know.
All right, kiddos. I gotta go. I'll be back in an hour, but I'll be keeping an
Thank
eye
you,
on
sir.
things.
Is this all of this witness?
And try to keep
Sir,
it
you may have a seat at
close
council
production
table.
times,
Thank you,
so.
sir.
Mr. Buck or Mr. Wolf, call your next witness.
I was told there's
No, we don't have any
fights.
further witnesses.
between the
The
lawyers
defense
that the
Okay, at this time, I'm going to show the defense
Bailiff
rest. Do we need to take up
had
any
to
motions or
intervene.
matters at the bench at this time?
All right, I'll be back.
Council will approach.
Are we doing instructions now too, or?
Assume you wanted to renew your motion.
Absolutely, yes. I want to know what the scope of what we're going to discuss is, and yes, I will
I
renew
don't
my
present
motion.
rebuttal proof, so we'll get to that here in a second.
Okay, yes, sir, of course. Yes, Judge. So based on the evidence that has now been tendered in its entirety to the court, counsel for Mr. Lawson renews its previously orally stated motion for a judgment of acquittal based on 10.24. I believe that based on everything we've heard, no reasonable jury could come to a conclusion that Mr. Lawson has in fact engaged in a conspiracy to commit murder as charged in indictment, I think 24 CR, 23 CR 371.
For the record, viewing the evidence in a light most favorable to the Commonwealth, we've got facts all over the place that you should argue to the jury, but the court finds there's sufficient evidence to instruct in this case.
Yes, sir.
The motion's denied. Is there any rebuttal proof? Okay, so that's all the proof at this time. Have you all had an opportunity to review the instructions?
Yes.
We have, Judge. I guess I have a couple of questions. You took out the solicitation section. I'm sorry.
I assume we'll discuss this separately, right?
You all want me to clear the courtroom?
Yeah, I think it
Yes,
can take a
sir.
little bit of time.
Yes, sir.
Sure, no problem. Okay, I'll tell them where we're at. Okay, Frank. Ladies and gentlemen, the jury, at this time, the case is closed. All the evidence is in this case. What I have to do right now is go over the jury instructions with the attorneys. They're going to have certain objections to that. There may be some changes. I don't know how long that will take. I'm going to estimate it'll take us about 20 minutes. When you all are in the jury room, I'm going to give you all an assignment. We can pick up sandwiches or pizza. I want you all to see if you all can figure out what to do for lunch, because we worked through lunch trying to get this resolved here today. So I know sometimes people have allergies or certain foods they can't eat. So make sure it's something that we can all do together. But I'm going to give you all that assignment to try to figure out what you all want for lunch. I know they said they'd like us to pick up pizza or Jimmy John's, something like that. So if you all can come to that resolution. Now, if you can't, I don't know if we'll get a decision tonight if you all can't come to a decision on food. So, but while you're in there, remember the same admonitions are in place. Do not discuss this case among yourselves. Do not let anybody discuss this case with you. If anybody attempts to, you need to immediately report that to me. And you're not to finally make up your mind. Well, all the evidence is presented. The jury instructions have been given to you. You consider what your fellow jurors have to say about the case. You may go with the vote. Randy, can you print all that money? Can you Everyone may be seated. At this time, with the record reflect, the 15 jurors have left the courtroom. Last night, the court had, I guess it was early this morning, about 5:30, I emailed to you all the instructions that I had prepared based upon what you all had sent to me. We'll take up objections. I'm sure I'll have some. My wife tells me I'm wrong all the time, so I'm sure you all are going to tell me the same. So I'll start first with the Commonwealth. Any objections you all have for the instructions?
Can you even hear us over here, Judge? I don't know if you can hear without the microphone.
I can hear you, but I don't know if you came up to that podium that would help, or
Is that better, Judge?
that's better for me. I don't know if you want to put on the microphone where everybody in the room can hear you or not.
Do they want to hear jury instructions? I'll be glad to.
Okay.
Judge, we had tendered an instruction. Excuse me. On conspiracy charge that involves solicitation, and I noted in the court's proposed instructions that part of the instruction was no longer in there. I think there is sufficient evidence for the solicitation part of conspiracy, even if the jury were only to believe that when Brooks asked Steve Lawson to commit the murder, and he said, "I'm not your man, but you have some people that might be. Charlie Girdley might do it," even if they don't believe that he went out and asked Charlie Girdley, which in fact there is testimony that he did. That interchange between him and Brooks Howe is sufficient for the solicitation part of the conspiracy. Just suggesting somebody who would help in the murder is sufficient in that part. And so we request that you put that part of the instruction back in there. I think it's a third part of the conspiracy statute in that section B there. The other question I have is regarding the facilitation instruction, and I understand the court is probably inclined to give a facilitation instruction. I don't think it's appropriate in this case because I don't think there's anything. I don't think that based on his actions, anyone could say that Stephen Lawson was wholly indifferent to the commission of the offense, that he had no interest in the offense occurring. It is obvious he's making phone calls to Brooke Houck. He's helping in the planning. He's lying for, you can take his actions afterwards too. He's lying for years about what went on. He has an interest in that. He provided testimony to the grand jury. He was getting something out of this. That takes you out of facilitation. That part takes you out of facilitation. You cannot, that is not wholly indifferent to the commission of the offense. And so I'm not sure if facilitation instruction is appropriate. But I would ask the court, if the court's inclined to give such an instruction, that we have some leeway on closing to explain that part of the law to the jury, that essentially Steve Lawson would have to be doing this out of the kindness of his heart. That's what wholly indifferent means. He has absolutely no interest in whether it occurs or anything he does happens. It means he just has to be a really nice guy and wants to either help Brooks out or help Joey out.
Any response to those arguments?
First off, Your Honor, as far as the instructions, let's confirm, did you receive, I assume you
Yes.
did, you received
And I
the
have-
instructions that we tendered?
Not only I received them, they're filed of record.
Okay, so they're now of record.
Yes, sir.
Okay, so the first issue that we have, Your Honor, is in the jury instructions to which,
Well, hold on, Mr. Wolf. Right now, I'm wanting your response to what she said, and then I'm going to get to your objections. Do you wish to respond to what she wants, a solicitation, instruction, and she doesn't want the facilitation in the instructions?
so, okay, let's take it one by one, Your Honor. I'm
Yes,
sorry, I want to make sure.
I'm giving you the opportunity to respond to what she's arguing about.
Right, so the first issue, I think, is what you just said, that she wanted a solicitation. Okay, we believe that the solicitation should not be included. We believe that, first off, as we've already stated, I don't believe that the jury instructions which the court has tendered to us for review, they, quite frankly, missed the mark as far as Cooper. And I'm going to just tell the court that as far as the solicitation, we don't think that that should be included in there. Okay. And the next issue, if you please will refresh me.
She doesn't want the facilitation in the instructions, the facilitation to commit murder.
Your Honor, obviously, when you reviewed it last night, I know that the email that you sent to us indicated you put a lot of thought into it. Facilitation is obviously a lesser included, we believe, a lesser included offense of the conspiracy. And that is why we asked for it. If you read the two jury instructions, Judge, there's some minute differences between a conspiracy compared to a facilitation. And I think that the evidence has been so murky in this particular case, Your Honor, that jury could reasonably believe that it was a facilitation compared to a conspiracy. And I know Your Honor has tendered the facilitation based on our request, and we ask that the facilitation remain in there. Again, given the facts that were presented to this jury, they're all over the board, quite frankly, and what they believe we believe they should have an opportunity to consider facilitation as a lesser included offense of the conspiracy.
And I'll give you a second here to go over your objections, but I'm going to
Sure.
go on the Commonwealth's right now, okay?
Understood.
All right.
Anything else on that?
That's all on that. Okay. As far as the Commonwealth's objections are concerned, and let me first state that the instructions in this case are very challenging. The reason they're challenging is we have a conspiracy to commit murder, and typically when you have a conspiracy to commit murder charge, there's no murder. Typically, it is 3 people get together. One of them says they'll get the gun. The other one does some type, and one of them may back out and go tell the police. And no murder ever happens, but there was a conspiracy to commit murder. When you read Cooper's instructions, it's very interesting. And they basically note that in there, that typically when you have a conspiracy, it merges with the actual charges. In this case, we have a conspiracy charge, but also the Commonwealth is contending that the murder occurred. So the Cooper instructions are not designed for the fact pattern that we have in this case. And that's why it's been very challenging for the court to determine the appropriate instructions in this case. As far as the solicitation is concerned, I spent a lot of time on that. And the reason I'm not providing that is when you read the definition of criminal solicitation, or in 506-030, it indicates that the person commands or encourages another person to engage. From what I heard in this case in regard to Mr. Gurley, it sounded more like a suggestion than a command or an encouragement to do that. So that's why the court did not include the solicitation. In regard to the facilitation, and the reason the court is doing that, when you read the definition of criminal conspiracy, the 8th or 9th word in there is facilitating. It says a person having the intention of promoting or facilitating the commission. So the court believes that facilitation would be a lesser included of criminal conspiracy, since the word facilitation is included in the definition of criminal conspiracy in 506-040. Before the record, the court's going to show that it has considered the Commonwealth's request. The court has filed of record their proposed instructions, so it would be available for appellate review if necessary. All right, Mr. Wolf, as far as your motions are concerned.
Judge, as you previously noted, you do have in the record already our previously submitted instructions. We, of course, as attorneys are basically, and I'm not sure where this came into play, but we all know, judges know, attorneys know that Cooper is where we go, right? Cooper is the Bible, for whatever reason, of the jury instructions. And in this particular case, we went to the Bible, and that Bible gave us some direction. And the direction that the Bible gave us on, it's very easy to see. It says right across the top.
Let me interrupt you for one second. Sir. Don't tell Cooper that you're giving him godlike status here, okay? But go ahead.
All right, I will back him down from being God, but we will all admit that's where we go. You probably have his book on the desk right now. Yes, sir. So it's my experience, that's where we start. And when we start with Cooper, we look at the instruction, and in this one, we look for the instruction of criminal conspiracy to commit murder. The heading is there. It says exactly what it says, which is it's line for line with what my client is charged with in relation to criminal conspiracy to murder. And it directs that there are things that have to be proven. And Mr. Lawson had to enter into an agreement with Brooks Houck. And what I'm doing, Your Honor, of course, is I'm parroting what I've already written for you and was submitted in our jury instructions. If you look at Cooper, of course, there's the blanks. They give us the example, but the example has blank spots in it. So I'm using what I think Cooper meant in relation to adding the facts of our case. And it says that in the county of Nelson on or about whatever day, blah, 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 that before the finding of the indictment, he, which would be Steve Lawson, entered into an agreement with Brooks Houck that victim, blank, Crystal Rogers, would be killed by and then it's got a parentheses and it says method. To me, that indicates that Cooper is requiring the Commonwealth to tell this jury, and this jury needs to make a determination exactly about what the agreement was, and that agreement specifically had an agreement between the two parties about how Miss Rogers would be killed. And if you continue on with that, you see that we've got additional statements in Cooper, which is just continues. It's really not additional statements, just the continuation of the instruction. And it goes on to say that defendant 2, method 2, and that would be, in our opinion, that would be Steve Lawson, that he did and with such action would constitute a substantial step in a course of conduct intended to culminate in the killing of the victim. When you look at the instructions that the court has tendered, that language is completely devoid. And I believe that language is important, and I believe that Cooper would not have included that language if that was not an important portion of the criminal conspiracy statute. And then it goes on to say that, this is B, that in doing so, it was the defendant's intention that Crystal Rogers would be killed by, enter, Brooks Houck. That, Judge, to us as a defense, is a very, as you can imagine, I believe that is a burden that has not been met here in this particular case. That, to me, is one of the most important sections that we are being deprived of by not having the court take the Cooper language and mirror the Cooper language more than it did in the proposed instructions that you tendered to us. And then it goes on to say in C, so this is an A, B, C, and D. These are all ands. Then you go to C, that pursuant to, in furtherance of, and during the continued existence of such agreement, Stephen Lawson and Brooks Houck committed, and then you've got to put some overt act, and that the defendant did not thereafter prevent such killing under circumstances manifesting a voluntary and complete renunciation of his criminal purpose. None of that is in the language that the court has used. And we believe that mirroring Cooper, the defendant is getting I don't want to call it the benefit of the doubt, but he's getting the application of the applicable law that should be in this particular case. And by stripping, quite frankly, all the language used by Cooper, we're not getting what the law in Kentucky requires in relation to a jury instruction in a case that is, quite frankly, it says right at the top, criminal conspiracy to commit murder. So it's our opinion that by not following, basically summary, by not following the Cooper instruction, Judge, we're being deprived of a legal right here, and that's that instruction.
Is that all your objections, or is there more?
I don't think there are objections. We just need to, of course, we need to change a thing or two. We've got the instruction number 2. I don't know if you want to go over that now. Instruction number 2 is the right to remain silent.
We need to take that out now.
Yes, sir.
Yes. Last night, I assumed he would not be testifying.
Yes, sir. And we also believe that if you're looking at the instructions, there's a continual statement, or they use the term murder. Of this murder, it's murder is in here about 4 or 5 or 6 times. It's our belief that the term murder should also be, we need a definition for murder. I know it seems maybe that is a commonly used term that shouldn't be defined, but we believe that the instruction should use the legal definition of murder, and we'll be glad to tender what we can find in relation to the legal definition of murder. Let me see. Might be the end. I think that's the extent of our objection. And of course, just for the record, just to make it super clear, we tendered instructions. They're in the record in any way, shape, or form that the instructions that are given to this jury deviate at all from what has been argued by me this morning, as well as what we have put in the record. We object to the same.
I have printed both of them and put both of your proposals in there, so it is included in the record for appellate review.
Yes, sir. Thank you.
Any response to that?
Judge, our response is, I think we've discussed this previously, is obviously Cooper's only deals with the first section of the conspiracy statute. That it's only written to address 1A. There is not a single word in Cooper's about agrees to aid someone in the planning of the crime. And so conspiracy was created to keep people from planning to commit a crime, getting together, forming a conspiracy, and then someone taking an act in furtherance of that. And that is that part that comes up in 506050. That's why you have the overt act. That entire section that's in Cooper's deals only with A. When it says substantial step, that's talking about the attempt part in A. There's every part of that is only addresses that first section of conspiracy. That's why we had to, all of us had to draft a brand new instruction for this, because it's just not in Cooper's. And it's not the first time I've seen an instruction that wasn't in Cooper's before, where you just had to start with the statute and try to work your way through it. And I think the court's instruction that's drafted complies with that. Now, if the question is whether we need a definition for murder somewhere or something like that, I think if the concern is there, you could put the word kill in that first sentence, in which you have the prerequisite, and I wish I had it in front of me, I do not, Judge. The very first sentence that starts out in Nelson County, Kentucky, and you're talking about with the intention of promoting or facilitating the commission. Can you tell me again? I'm sorry, Judge. I don't have it sitting here in front of me. I don't have it printed out. Exactly how that reads.
I had flipped the page, so.
The one that you have.
Oh,
yes, sir.
you're talking about the instruction that I've prepared?
Yes, I don't have a copy of it in front of me, and unfortunately, I can't hook to the internet in here right now.
Okay, so which portion do you want me to look at for you?
I just want you to read the very first part that you drafted on the criminal conspiracy statute.
Under A, under subsection A or subsection B or C, which one are you looking at?
Just under A.
It says that in Nelson County on or about July 3rd, 2015 and or July 4th, 2015 and before the finding of the indictment herein, the defendant acted with the intent to promote or facilitate the murder of Crystal Rogers.
I guess you could say the killing of Crystal Rogers, if you so desire. But murder, I don't think is a difficult term for someone. I think that's a common term for someone to understand. That's an intentional killing of someone, as it's used in this case.
All right. First of all, I have taken out instruction number 2 since the defendant has testified here, which will renumber everything. So we'll have instruction number 3 would now be the lesser included in the conspiracy to commit murder, and I'll change the numbers on the verdict form. First, I believe one of the objections that Mr. Wolf had was that there's not a method that's been put in there, and Cooper has a method listed in his instructions. And again, the typical conspiracy to commit murder case never happens, and law enforcement learns about the conspiracy of how they were planning to do this act that never occurred. So this is completely different than the normal criminal conspiracy to commit murder case. The court has certainly considered the argument that Mr. Wolf has made. However, when you read the statute for conspiracy, the statute in Kentucky does not require a method. So the court has followed the language in the statute as best as it can to instruct the jury under the law. In regard to murder, Mr. Wolf, you indicated that Cooper wrote the Bible. Cooper decided not to give a definition of murder, so the court's not going to give a definition of murder. The court believes that's a word that a jury would understand. So what I'm going to do is I will go and make these changes, bring copies back to counsel before we start. When the jurors come in, they'll all be given a copy of this. Will you all be ready to start your closings in about 11:05-ish? Okay, 11:05, we'll do closings. Court's in recess. I can have counsel come up to the bench for a second, please. Very important question. This may be the most important question. How long do you anticipate your closings going for? Because they're ordering pizza for the jurors. Do you have any idea?
I probably have a half hour.
Half hour?
Yeah,
I know
20.
Okay, so they should have the pizza there by 12:10 would be a good time to say. Perfect, thank you all. I told you it was an important question.
Yes, the most important.
All 15 jurors have returned to the courtroom. Everyone may be seated. Thank you. Ladies and gentlemen of the jury, I believe counsel waived a call with the jury.
Yes. So wait.
Ladies and gentlemen of the jury, I believe they handed you a copy of the instructions. So what I'm going to do right now is read those instructions to you. So if you'll follow along with me. The jury is instructed as follows. Instruction number 1, presumption of innocence. The law presumes a defendant to be innocent of a crime, and the indictment shall not be considered as evidence or as having any weight against him. You shall find the defendant not guilty unless you are satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that he is guilty, you shall find him not guilty. Instruction number 2, definitions. Intentionally. A person acts intentionally with respect to a result or to conduct when his conscious objective is to cause that result or to engage in that conduct. Physical evidence means any article, object, document, record, or other thing of physical substance. Official proceeding means a proceeding heard before any legislative, judicial, administrative, or other governmental agency or official authorized to hear evidence under oath. Instruction number 3. Under this instruction, you may find the defendant not guilty, or you may find him guilty of conspiracy to commit murder or facilitation to commit murder. Instruction number 3A, conspiracy to commit murder, Class B felony. You will find the defendant guilty of conspiracy to commit murder under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in Nelson County on or about July 3rd, 2015 and or July 4th, 2015, and before the finding of the indictment herein, the defendant acted with the intent to promote or facilitate the murder of Crystal Rogers. And B, that in so doing, the defendant agreed to aid Brooks Houck in the planning of this murder. And C, that pursuant to and in furtherance of that agreement, the defendant transported Joey Lawson to the vehicle of Crystal Rogers with the purpose of relocating said vehicle. Instruction number 3B, facilitation to commit murder, Class D felony. If you did not find the defendant guilty of conspiracy to commit murder under instruction number 4A, that should be 3A. I apologize, I missed that. So that should be 3A. I'm going to make that change on the original. You will find the defendant guilty of facilitation to commit murder under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in Nelson County on or about July 3rd, 2015 and or July 4th, 2015, and before the finding of the indictment herein, the defendant acted with knowledge that Brooks Houck intended to kill Crystal Rogers. and B, that the defendant agreed to assist in moving Crystal Rogers' vehicle while knowingly providing Brooks Houck with the means or opportunity to kill Crystal Rogers, and C, that the defendant participated in the movement of said vehicle which aided Brooks Houck in killing Crystal Rogers. Instruction number 4, tampering with physical evidence, Class D felony. You will find the defendant guilty of tampering with physical evidence under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in Nelson County on or about July 3rd, 2015 and or July 4th, 2015, and before the finding of the indictment herein, he altered the driver's seat of the vehicle of Crystal Rogers, which he believed was about to be produced or used in a criminal proceeding, and B, that he did so with the intent to impair its accuracy, and C, that the driver's seat was physical evidence as defined under instruction number 2, and D, that the criminal proceeding was an official proceeding as defined under instruction number 2. Instruction number 5, unanimous verdict. Your verdict must be unanimous, it must be in writing, and it must be signed by one of you as foreperson. And then there's a place where I will date and sign the original. That's the form you'll return to me. Attached are your verdict forms. Page 5 is instruction number 3 verdict form. You have 3 choices there. Choice number 1, we, the jury, find the defendant not guilty of conspiracy to commit murder and facilitation to commit murder under instruction number 3. Or choice 2, we, the jury, find the defendant guilty of conspiracy to commit murder under instruction number 3A, signature line for the foreperson. Or your third choice, we, the jury, find the defendant guilty of facilitation to commit murder under instruction number 3B, and there is a signature line for the foreperson. The next page is the verdict form for instruction number 4. Got 2 choices. Choice 1 says, we, the jury, find the defendant not guilty of tampering with physical evidence under instruction number 4, a signature line for the foreperson. Or choice 2, we, the jury, find the defendant guilty of tampering with physical evidence under instruction number 4, and there's a signature line for the foreperson. So at this time, Mr. Wolf, are you ready to do your closing?
May I
proceed when you're ready.
Thank you, sir. May it please the court, counsel for the Commonwealth. Mr. Lawson, Mr. Butler. And most important, ladies and gentlemen of the jury. I'd like to start off by basically thanking you for your attention to this matter. As I sit over there and prepare for the next witness or get ready for what I'm going to do next, I do watch the jurors, and I'm sure that I've gotten contact with each and every one of you through while I was over there, and I can tell that each one of you has considered and listened to each and every piece of evidence in this case. And I'm comfortable and confident that when you listened to all of this evidence, you took down notes. And if you didn't take down notes, you remembered certain things that were important to you. And I'm comfortable and confident that when you go back and deliberate, that you will do the right thing in this case. Now let's talk about what the right thing in this case is. You folks will remember, I got up in the opening. It was me. I came up and I talked to you. And I looked at each one of you. And I told you that we were going to admit what Mr. Lawson's involvement in this case was. Do you remember me telling you that? I told each and every one of you he would absolutely admit that he is guilty of tampering with physical evidence. That has not changed. I have kept my promise to you. And more importantly than me keeping a promise to you, Mr. Lawson has kept a promise to you. And that promise was to own up to what his responsibility was in this particular case. So, as you look through the jury instructions, I see some of you looking at them now, we're making it easy in relation to the tampering with physical evidence, right? The tampering with physical evidence, that is on your jury verdict form. So, what you're going to be able to do is go to
Instruction number 4. Instruction number 4 has a whole bunch of words that culminate with whether or not you believe that he is guilty of that particular charge. Guess what? You don't have to spend time on that because we have admitted to you that the elements of that offense have been met. So the next thing is we need to figure out legally under the law, and thank you, Amiel. Let's take a look just briefly. This is the tampering with physical evidence instruction that you have in front of you. This tells us what Steve Lawson's involvement was in this case. It's our position that that's the extent of his involvement. So with that, again, we've made your job easy on that particular portion. You can find him guilty of tampering with physical evidence. That's a Class D felony. Write that down. The more difficult part of your job is determining whether or not Mr. Lawson is guilty of any other offenses in this particular case. I'm going to tell you that after having this case for over a year and reviewing all the evidence, that it is my belief that the evidence that was produced to you today and the day before and the day before falls very short of meeting the burden the Commonwealth has to meet. And let's remember, can't ask you directly, but I think I'd just like a nod. The burden here is beyond a reasonable doubt. Would everyone agree with that? The burden is beyond a reasonable doubt. This table carries the burden of every single element in the 2 charges that we're not conceding to, because think about it, there's 2 that we're not conceding to. We all agree with that? We concede to 1, boom. We don't concede to the other 2. Every single element. When I say element, I mean, and let's go to instruction 3A. When I speak of the term element, and I know as a lawyer, I sometimes say these things like people understand it. And I know that that's just something in my vernacular. Anyway, the point of the story is each of these things that you read here is an element of the offense. So A is an element of the offense. B is an element of the offense. And C is an element of the offense. And within A, B, and C, there are a bunch of words. And I'll get to how important those words are here in a minute. But the point is that they have to prove to you beyond a reasonable doubt every single thing. For example, let's just look at this part. That in Nelson County on or about July 3rd, 2015 or July 4th, 2015, they have to prove that beyond a reasonable doubt. Do you think I'm here saying that what we're talking about didn't happen on that day? No, I'm not saying that, am I? What I'm saying is that the other language clearly is not met beyond a reasonable doubt. And I'll get into that a little bit more in a second. So the point is that when you're deliberating, there's going to be an open dialogue, hopefully an open dialogue by the 12 of you that are randomly chosen. I don't know if we talked about this before, but we'll tell you now, there's 15 of you sitting here. Only 12 of you are going to go back and deliberate. The other 3, it's not that we don't like you. It's just that, randomly we only allow 12 people to go back and deliberate. So the 12 of you are going to go back. You're going to have an open discussion. And my hope and prayer is that every one of the 12 people that deliberates thinks through the facts that have been presented to you in this case, independently of the other 11. I'm not asking you to not get insight from the other 11. By all means, talk it out. That's what a jury does. A jury is supposed to deliberate and have discussions. That's why we don't just have one person on a jury, we have 12, okay? We want you to openly discuss it. However, with that open discussion, if you have a reasonable doubt about any of the elements in the 2 charges that we have in front of you, basically, that we're asking you to truly consider, hold to your passion. hold to the idea that you have an independent thought and that the other 11 people shouldn't sway you from that thought. Each and every one of you has an independent obligation to the jury system to do your job. And your job is to independently view the evidence, come to your own conclusions. And if there's a one of you in the 12 that has any belief that any of the elements, just one of the elements of each of those charges is not met, if they have not met the burden beyond a reasonable doubt, what does that mean? That means that the government has not met their burden and Mr. Lawson is not guilty. Is not guilty. I believe after you review it and have a firm discussion and an open discussion, each of you is going to come to a conclusion, probably different from the others, but by the time you're done talking, you're going to hopefully come to some reasonable and logical conclusion. The logical conclusion is Steve Lawson, as he sits here today, is guilty of a Class D felony, and that Class D felony is tampering with physical evidence. That's what he's guilty of. Now, I do want to go back and talk about the instructions a little bit more because, quite frankly, they're confusing, okay? There's a lot of words. And quite frankly, I struggle with them sometimes because there's just so much verbiage in there, so much verbiage. So I want to highlight a few things that I think when you go back and discuss with each other that I'd like you to seriously consider. And I'm going to discuss those with you now. If you can let's put up instruction number 3, instruction 3A. Instruction 3A is the one where the government's going to ask you to find him guilty of conspiracy to commit murder, a Class B felony. Class B felony, okay? Obviously, the most serious charge of all. So let's talk about that charge, okay? That in Nelson County, on or about July 3rd, July 4th, 2015, before finding an indictment given, the defendant acted with the intent to promote or facilitate the murder of Crystal Rogers. To promote or facilitate the murder of Crystal Rogers. What does that immediately require you to determine beyond a reasonable doubt? What does that require you to do? It requires you to come to a conclusion that Crystal Rogers was murdered. You've got to conclude that. You have to conclude that. Let's think about that. Was the evidence here beyond a reasonable doubt that Crystal Rogers was murdered? Was it? I don't think so. It's not what I heard. Let's move on. If you get past that, you got to go to B, right? That's an and.
You're objecting.
You may.
Judge, you have to have the intent to promote or facilitate, not to complete the crime. That is a misstatement of the law, and he needs to correct it.
What the jury instruction says. They can get up and they can change. They can get up and argue what they want.
You do not have to find that the act has been completed. You have to find that when they engaged in this conduct, there was an intent to promote and facilitate the commission of
I'm
murder.
going to tell the jury there to follow the language and the instructions.
Thank you, sir.
Thank you.
Ladies and gentlemen, the court just needs to reiterate, you need to follow the exact words in the instructions. You may proceed.
And what that, see if I turn myself on. And what that indirectly tells you is, from what you just saw, there's going to be a disagreement between myself and the Commonwealth as to what the language is and what the language requires you to do. They're going to be able to get up and talk after I'm done talking, and they'll explain what they believe. And it's going to be up to the 12 jurors to go back and decide what you believe, okay? What you believe the instructions require you to do. So we'll leave that with you to determine what you think those instructions require you to do. And I will note here, I usually say it at the end, but I want to make sure I don't forget it. Do you know why you get to hear from the Commonwealth last? Do you know why I'm up here now? It's not just a courtesy to the defense. That's not what that is. I am up here now because they get the last word. Why does the Commonwealth get the last word? The Commonwealth gets the last word because the burden of proof in this case is on them. There is no burden on us. The burden is on them. That's why they get to speak to you last. That's how that works in our legal process. Another thing you didn't pick up on, but I shouldn't say you didn't, but you may not have. Why do you think that the Commonwealth in this table is closer to the jury box than our table? Same reason. The burden's on them. And don't ask me where that came from. Okay, came around way before I got around. But the point is, they're not only do they have the burden, but there's little reminders in our judicial system that tell people that the burden doesn't belong to the defendant. The burden belongs to the prosecution. Back to the instructions. The instructions, moving on to B. No, same instruction. B of that instruction, okay? So what are we doing? Again, we're on the Class B. They're asking you to find him guilty of a Class B felony, okay? That Class B felony, the second section here, and of course, these are ands. They're not ors, they're ands. So every one of them has to be proven beyond a reasonable doubt. B, that in doing so you have to believe this first, that in doing so, you get past this, the defendant agreed to aid Brooks Houck in the planning of this murder. Where did we hear in the evidence that Steve Lawson agreed to aid Brooks Houck in the planning of a murder? The planning of a murder. That's the important part. That's the important language. The planning of this murder. Did we hear anything about that? What evidence did they show us that he was involved in the planning of this murder? It wasn't, you know what it doesn't say? It doesn't say in the planning of the movement of this car. It doesn't say that. It says the planning of the murder. You didn't hear that because that's not what happened. And if by some chance you get past that, you get down to C. C is that pursuant to and in furtherance of that agreement. And what agreement is it? It's the agreement related to the murder. That pursuant and furtherance of that agreement, the defendant transported Joey Lawson to the vehicle of Crystal Rogers with the purpose of relocating said vehicle. That one's not quite as controversial, of course, because we admit that he did in fact go out with Joey Lawson and move the vehicle. But you're not going to get there. You're not going to get there. Why? Because A and B are simply not met. They're simply not met. Now, let's move on. Amiel, let's go to 3B. Okay, we're going to do the same process here. 3B. Same process. That in Nelson County on or about July 3rd, 2015, and or July 4th, 2015, before the finding of the indictment, given. The defendant acted with knowledge. Here's why this one doesn't apply. The defendant acted with knowledge that Brooks Houck intended to kill Crystal Rogers. Intended to kill. That Steve Lawson had the knowledge that Brooks Houck intended to kill Crystal Rogers. Did we hear that beyond a reasonable doubt? We didn't hear that beyond a reasonable doubt. You know why? Because it didn't happen. Didn't happen. He didn't have knowledge that Brooks Houck intended to kill her. He didn't have that knowledge. But if you get past that, let's go on to the next one. That the defendant agreed to assist in moving Crystal Rogers' vehicle while knowingly providing Brooks Houck with the means or opportunity to kill Crystal Rogers. Well, what's that mean? I don't know. You tell me. I'm not sure what that means. I tell you what it means, even though I don't know what it means. It means something, okay? You can't just go past that and act like that's not in there. You all need to sit and think, what does that mean exactly? The means or opportunity to kill Crystal Rogers. Means or opportunity to kill Crystal Rogers. Well, I don't know what it means. I do think it requires at least at a minimum, that Mr. Lawson needed to do something that aided Brooks Houck in the killing of Crystal Rogers. I think that's the minimum that it requires. I'll let you chew on that when you go back and deliberate. But it is, as we've talked about before, it's an element of the offense that must be proven beyond a reasonable doubt. So, what do we have now? We don't have any more instructions. We have three possible guilties here. Three possible. Giving you one, the tampering. We're not giving you the conspiracy, and we're not giving you the facilitation. We do not believe that each one of those elements has been proven beyond a reasonable doubt in this case. Beyond a reasonable doubt. It's just not, quite frankly, it's just not close based on the evidence that was brought in front of you and the information that was brought to you. Now, what I anticipate, because I've done this enough, what I anticipate is when I sit down and the government gets up here and they have the last word, they're going to say words to the effect, use your common sense. I think they're going to tell you that. They're going to tell you to use your common sense. I'm going to ask you to consider this. When they say that to you, what they're asking you to do is not look at the facts, okay? The evidence that was presented in this courtroom is the evidence in the case. That's the evidence. If they didn't bring something in here and make it a part of the evidence, then it's not evidence, okay? It doesn't work to convict Steve Lawson if it wasn't brought in here. So there's going to be gaps. When you go back there, there's going to be gaps. Well, we don't know enough about this. We don't know enough about that. The Commonwealth would say, don't worry about that. Don't worry about it. Just use your common sense. Fill in the gaps with common sense. That's what I have experienced over the years. A fancy way of saying to you, we don't have the evidence that we need. It's all circumstantial. And we can't do what we need to do to fill our burden. But don't worry about it. Don't worry about it. Apply your common sense. Don't do that, okay? Don't allow the Commonwealth to get up here and have you completely overlook what your obligation is. And your obligation is to look at the evidence and make sure that what you heard over the last 3.5 days fills their burden. That's what your obligation is. I'm not saying not to apply common sense, but don't allow that statement to be used to have you overlook things. If the evidence wasn't brought in here, you can't just use your common sense and say that it was. It's not the way we work. It's not what our judicial system is about. Did you see any instruction when the judge was reading it to you that said common sense? No, you didn't. You didn't see that, okay? So beware. I agree that common sense is applicable, but it's not applicable when reading jury instructions and deciding whether or not the government has met their burden in a case like this. few more things to think about. I promise I'll sit down here. So that your pizza will not be cold by the time you get back there. A few things to think about. I'd ask you to seriously consider a question of why are we here today in judgment of Steve Lawson, when we know from the government's own case, we know from their own case that it is still being investigated. To this very day, the disappearance of Crystal Rogers is still being investigated. They are still taking leads. There's still phone calls coming in. They're still investigating. Some might say, you know, we probably need to do a full, thorough, complete investigation, wrap it up before we put this in front of a jury and ask a jury to convict a man of a Class B felony. I'd ask you to think about that. Can we at least complete the investigation before we come in here and ask you folks to put this man away for what will most likely be to the end of his lifetime? Let's talk about something else that you heard that the Commonwealth is potentially going to get up here and talk about, but they may not, because I don't think it's very helpful for their case. Before we put a jury in the box, we want to ask them, we desire to ask them to convict a man of a Class B felony. Before we do that, do you think that we should do as much possible investigation as we can? We've already talked about the investigation still open, but let's talk about, just briefly, we heard about a couple of hairs that were found in Crystal Rogers' vehicle. Do you remember that? We talked about that, right? You all heard about that. Those hairs were never tested. You heard that too, right? We had Dr. Wright come on here. Remember Dr. Wright, the only person that testified via Zoom? What did Dr. Wright tell us? Dr. Wright, in response to the questions of the Commonwealth, said, well, we can't conclude whether something's relevant or not unless we test it. We got to test it before we can make that determination. Remember he said that? And you may say, well, Mr. Wolf, what does it matter that there were two hairs in Crystal Rogers' vehicle when you've just come in and admitted that your client was guilty of tampering with physical evidence? The reason it's important is we don't know, we have no idea who was in that vehicle other than Joey Lawson before this happened and during the event that happened. You heard my client, he never got in the vehicle, never got in it, never got in that vehicle. There's additional hairs out there that were never tested, never tested. What if those two hairs belonged to someone that was in the National Crime Database, okay, that had a felony conviction for murder? What if those hairs belonged to somebody else that was an unknown serial killer? What about that? Okay? I don't know. I don't know if they were. You know why? Because they weren't tested. They weren't tested. But if they were, you would be sitting here with additional information that they did not give you. They didn't give it to you. And they want you to say, don't worry about it. Don't worry about it. It's not relevant. Not relevant. Not relevant. BS. When you're going to do this to a man, when you're going to ask somebody to take away his freedom, you test it. Just to be safe, you test it. And you don't come in here and tell a jury of 12 that it's not important. You don't do that. You don't do that. Let's talk about another issue. The vehicle. The vehicle. The actual vehicle in this case. What did we hear about the vehicle? It was turned back over to the Ballard family. Do you remember that? It was turned back over to them almost, I don't know, what was it, a couple months? A couple months. And then where did it end up? Do you folks remember where it ended up? It ended up basically on a Hollywood show with a third-party guy who calls himself an investigator doing an analysis of the vehicle. How does that happen? Joey Stidham.
Judge, I don't believe that was supported by the evidence.
I'm sorry, I can't hear you.
I'm sorry. I'll just withdraw the objection.
Show objection withdrawn.
If we're talking about a case where the Commonwealth believes that my client engaged in some kind of conspiracy to commit the murder of Crystal Rogers, and the last place we know her to have been was in her vehicle, how in the world does that vehicle get turned over to a Hollywood company to do an investigation to be put on television without it being held by the Commonwealth? How does that happen? That defies logic. It is an absolute absurdity to think that car should not have been maintained as evidence to this very day, so that it could be checked out by the defense. It could be checked out by other people. No, it was turned over to the Ballard family. What are we doing here? This is crazy. But look the other way. Don't worry about that. That's what they're going to tell you. Red herring. Wolf doesn't know what he's talking about. He's trying to take you down a road. Well, the road is a complete investigation of what happened in this case before we convict people of crimes. We don't utilize the long arm and the strong arm of the Commonwealth, the only charging agency besides the federal government in the state of Kentucky. We don't utilize that process. We don't utilize their ability to charge people without doing a proper, thorough investigation. It's not what our system is about. It's not how we do things here in America. We're not in a third world country. Another thing they're going to tell you, though, don't worry, look away. You remember, you heard it very briefly. But do you recall that there was evidence that Miss Rogers' Social Security number was used in 2019 to file a tax return? Do you remember that? There was a tax return filed with her Social Security number. I don't know where she is. And I hope and pray that she is alive somewhere and this is all just a big mistake. I hope and pray that. Okay? I really do, for her and her family. What did we hear in relation to the IRS? Did anybody come in here and say that we went and looked at that? We went to the house that the return came from? Did we hear any of that? We didn't. You know why? Because it didn't happen. We heard Mr. Young tell us in his cross-examination, well, people were stealing back then, remember? It's all fraud. It was all fraud. It was all, something about President Trump or something, if I remember what he said. It's all fraud. Pure speculation, okay? The fact is, somebody did file a tax return with her Social Security number in 2019. Don't you think that's something that we should have looked into? Do you think that's something that we should take and run with? I would think so. Before asking somebody like Steve Lawson to go to prison for an extended period of time, I think we check every one of the boxes. We look at everything. One of the things that happens when a person is charged with a crime and he decides to take the witness stand, one of the things that happens, there's a tendency for people to think that the burden of proof is no longer on the Commonwealth and that somehow that burden of proof has shifted to the defense. And now all you have to do is believe or not believe what Steve Lawson told you. And if you don't believe him, then somehow he is guilty of the crimes as he is charged. I'll ask you to stay away from that fallacy. That's a fallacy. That's something that's not true. He got up here and testified. You may not have believed everything he said. I don't know. I don't know if you did or not. I believed everything he said because I've been involved in this case for an extended period of time, and everything he said checked out to me and checked out from the beginning. Everything. But you may not feel that way. But guess what? If you didn't believe something that he said, you're still obligated to go over those jury instructions and find each and every one of the elements to have been proven beyond a reasonable doubt. Okay? So keep that in mind. Please keep that in mind. That did not shift the burden to the defense in any form or fashion when he got on the witness stand and told you his story. It didn't happen. And I give him credit for doing that. Vast majority of my clients don't get on the witness stand. They don't. Okay? He has something to hide. You don't want to tell everything. You didn't hear that here. You heard an honest, heartfelt rendition by this man about what happened the night of July 3rd, moving into the morning of July 4th. You heard from him what happened. You heard. And as he stated to you, he didn't know about the murder. That's the key here. He didn't know about this, call it a murder, but was it a murder? I don't know if it was a murder or not. I don't know. And you folks don't know either. You don't know because that's not been proven to you. There's no proof that there even was a murder, let alone an agreement to commit a murder or an agreement to do something in furtherance of this magical murder.
I'm back. Did I miss anything?
Here's what we're doing. Here's why this courtroom is full of people. I don't know, standing room only maybe. Here's why we're here. And I think it should be obvious to you folks. We're here because the Commonwealth has decided that enough time has elapsed. We now need to bring closure for the Ballard family. That's why we're here. We're here because of a conscious decision by the government to bring closure to this family.
I've missed nothing. Okay.
Ask
Did the lawyers
yourself,
fight yet?
What closure are we possibly going to give the family when we still don't know what happened to Crystal Rogers? What closure are we going to give them?
I missed nothing much. Okay.
This was a rush. I know it sounds
there's Mama.
kind of counterintuitive when I say this to you. Sounds counterintuitive. This to me was a rush to the courthouse. It was a rush to the courthouse. 10 years, right? How could that be a rush? It was a rush to the courthouse because there was enough outside pressure to appease the community, to appease the Ballard family, and get somebody on the hook and somebody found guilty in relation to the disappearance and murder of Crystal Rogers. That's why we're here today. And as much as I feel sympathy for them, as much as I feel sympathy for everybody in here who is showing their support for Crystal Rogers, my allegiance is to the Constitution of the United States. The Constitution of the United States requires us to not put people in jail, to not take away their liberties, to not do anything to them until they have been given a fair and adequate trial with any and all evidence being presented to the jurors. That's what they're entitled to. That's what our Constitution commands of us. We're here in Bowling Green, Kentucky. Last I checked, we're in the United States, and we're entitled to those protections. Each and every one of you is entitled to those protections, and everybody at that table, and everybody in this jurisdiction, everybody here is entitled to it.
Everybody.
Let's not, because we feel bad for the Ballard family. Let's not, because we want to close a chapter in this mystery. Let's not allow that feeling that's tugging on our hearts to close this. Let's not allow that to overcome your obligations as jurors to look at each and every element, and make sure that that table has proven beyond a reasonable doubt each and every element. Remember, talked about this at the beginning, right? Remember that rock? Everybody remembers the rock, right?
Hi, Choo-choo.
They started with the rock. What did I do? I said, I like the rock, but you know what? It's not on my table. It's not over here. The rock is over
That's where
here.
I left off.
The rock is on this table, and it's their burden to pick up that rock and drop it over on this side. Let's not allow the movement of that rock to take place to appease a hurting, longing community searching for answers for the disappearance of Crystal
You
Rogers.
as well.
Let's not do that. Let's not do that. This is a sanctuary. You folks are in a sanctuary. That sanctuary is the criminal justice system. It's the jury box. You're in that sanctuary. Do not allow outside pressures, speculation, and lack of answers to lead you to a conclusion that just takes care of people's concerns for closure. Closure is not what we're going to get here. We're not. We're not going to get closure. We're not going to bring Crystal Rogers back. That's not going to happen. Please, when you go back and deliberate, look at each and every element, analyze them to the extent that you feel necessary to believe that each and every one of them either has or has not been proven beyond a reasonable doubt. That's your job in this case. That's your role here. And I'm convinced that when you listen and look and review the evidence that you've heard over the past 3.5 days, that you will believe that the government has not proven beyond a reasonable doubt that this man right here has committed either the act of conspiracy to commit murder or facilitation to commit murder. Thank you very much.
Well, I agree with them on those points. I feel like the comment about the Ballard family and getting closure, while I agree is probably what happened, I don't know if that was really a good approach to this closing argument. But, oh, we got Steve, or Shane. See, I'm just going to keep calling him Steve because, oh, no, wait. Oh, nope. We got Orville. Oh, great. I like Orville. He's not as sassy as the other one, but boy, does he get all... Sir, wrap it up. It's true. But maybe you can say that in a better way.
Police Court, Judge Sims, my colleagues on this bench. Good morning, ladies and gentlemen.
What's his name? Lewowski, I think.
Sometimes in the old days, when I was with the U.S. Attorney's Office and prosecuting cases, I would come out with a rebuttal that was necessary. So a couple things I want to put to rest.
Did he already do his closing in this
One
rebuttal,
is,
or
we're not here,
is this his first time?
and it would be offensive if we were, simply because we feel like 10 years, we don't care what the proof is. We want some resolution for the Ballards. We're here. You've heard the evidence. We're here because this man, by his own words, put himself in the middle of conspiracy, an evil conspiracy. You heard him tell you what he was doing. He knew because Brooks Howe, the person he partnered with as a conspirator, told him We need her gone. Now, he may play with words in front of you all. You heard what he said to the grand jury. He understood that meant to cease.
Thank you.
Before he took a step in the direction of moving that car, before he moved that car, he knew the plan was to kill that young lady. He knew it and carried it on. And he needs to carry that on his shoulders. He could have stopped that at any time. Just as you heard in the jail call. He knew she was going to be killed. That was the plan. They needed to get rid of the car. Use your common sense why. They wanted to create the illusion that she left to the high hills. Gone. We don't have to prove they actually murdered her. You need to struggle with that. Did he act to and facilitate in the direction of getting her murdered? That's a crime. That's a conspiracy to commit murder. Don't be afraid of common sense.
I have no hate for Miss Sherry Ballard.
That's insulting. Common sense are the fundamental ways that we resolve issues like this every day in our jobs.
Can't wait to see our
taking care of our children, grandchildren. It's how we make things work. It's what God has given us, thank God, to resolve our problems. Use your common sense. Whatever that decision may be, you all use it. It's a powerful tool to resolve issues. I'm not telling you that because I want you to skip over evidence or ignore it. We're duty bound as prosecutors to abide by the law and appreciate what the law is and what evidence we can bring into this courtroom. Now, what do we know? The first instruction is to promote or facilitate the murder of Crystal Rogers. In doing so, he agreed to aid Brooks House in the planning of this murder. And pursuant to this, in furtherance of the agreement, the defendant transported his son, Joey Lawson, to the vehicle Crystal Rogers, and the purpose for relocating that vehicle. Well, that's absolutely exactly what this man did. He was approached by Houck by his own words. This is not my words. These are the words of this man you all listened to. He tried to put him out of his mind.
About it.
Bring up new words.
The justice.
He was playing with you. Brooks Houck asked him to move Crystal's car. That wasn't a move down the street to park. He won't tell you. I asked him, what did he want to do? Didn't know. Just move the car. He knew at that moment, we need to get rid of the car.
Not to be that person, Juju, but those questions.
We want to make it look like she's gone. Left her children and her family.
I do love y'all crazy Lawson. I love that.
He knew that. That was the plan. It's ridiculous to say he didn't. Pathetic. But that's not the only thing he knew. Brooks Houck told him, I need her gone. He told you, you heard it in his words, it meant to cease.
Excuse me.
Brooks' plan was to
Get some
kill
fruit.
this young woman. And how did he know he took it seriously? He reached over to Charlie Girdley. Maybe Girdley will do it. Remember that when you heard that? I'm paraphrasing Trump, but he was going to go to Girdley. He was going to find Girdley and see if Girdley will take care of this problem that Brooks Houck had. He knew the plan was to kill this woman. Every step he took after that was to facilitate and promote that plan of Houck's to kill that young woman. That's undeniable. He can play words with you and I this morning, but that's what he told the grand jury in September of 23, and that's what the truth is. What else tells you that? He wants you to think all he did was he just took the car and drove it around. Well, his conduct after July 3rd, belies that statement of his.
It can be, yes.
He lies.
It's their state statutes are worded differently.
We went
everywhere.
through 8 or 10.
Just like Kentucky does
with
not
the
have a
FBI
first-degree
agent
murder
as an
charge.
example.
It's
I've never left the house
complicity
that night
murder or
of February
something.
the 3rd. Remember him
They word it
telling me
weird.
that? I was drinking. He uses drinking as a way to mask his conduct, hide, an alibi for his conduct. It's ridiculous. He knew exactly what he was doing. He lied and said, I never left the house. Why? Because he was out. He was outside tracking the car of this young woman. Where was it? It broke down. Let's get Joey, take him back. And then throughout that night, he's up on Thompson Hill and wants to tell you I'm out drinking. Just a coincidence. Just a simple coincidence. Don't use your common sense. He's up on the hill 4.5 hours. And it's just a coincidence. Those are the hours that this young lady was killed. They had no role in that. I was just up there drinking. Comes back again several times. You saw it on the forensic evidence on the movement of his phone throughout that day. He is cleaning up the crime, helping it out. He calls at 12:07. First of all, Joey calls Steve at around 11:58, July the 3rd. And they talked for almost 3 minutes. You saw that in some of the evidence we had. 3 minutes. Well, he obviously is talking about more than, hey, I got a flat tire or broke down. They're trying to figure out what's plan B. What are we going to do?
Is Jim Beam Kentucky?
And they're talking
or...
for 3 minutes. That's what makes common sense. So he calls Brooks and he says, I told him I moved the car. That doesn't make any sense. That doesn't make a lick of sense. He called Brooks Houck. That must have scared the heck out of Brooks Houck. They're in the middle of this crime. And he gets a phone call from his conspirator, his co-conspirator. And it wreaked havoc for Brooks Houck, that phone. what he's telling Brooks out is that, look, we're in trouble. We, and Brooks House probably closes that phone down because that puts now Brooks House and Steve Lawson together. And they stumbled. They made a mistake. So we got to cover that phone call at 12:07 on July the 4th. We got to cover that. Brooks House must have been sweating, wondering what they were going to do. He fouled up, made this call to tell them that they obviously had to tell them we broke down. So he tells you in the grand jury, you heard it. It's not just my words, it was his. They made up a phony story. They figured John Snow, the lead detective, this gentleman here, was going to be investigating Brooks. He told you on July 5th, I started talking with him. Brought him back in on July the 8th. That the Snow was trying to find out what happened to this young lady. And did something awful happen to her. So he brings in Brooks House.
I like him better than Shane, that's for sure.
And
exaggerator, but
John Snow finds there's a phone call at 12:07, right at the time when this young woman is missing.
Oh, Jim Beam is Tennessee too. Okay. I feel like Kentucky has some bourbon whiskey brand. I don't drink bourbon or whiskey. Trust me. Get in trouble when I do.
They get on the phone. He kind of, I got some work for you, and just to lead in. I don't even know what was that call about. It was about getting his stepdaughter Lauren a house. That's why I called you. He tells you that was a lie. That was a cover-up. That was to try to get John Snow turned away from this issue. He didn't, but that's what they wanted. Why would he do that if he wasn't an important asset to this conspiracy to kill? He did it, like every criminal, to lie and cover up from their crimes.
I do.
He admitted it.
But my mom's listening somewhere.
And for time after that, I played you with the FBI agent, Mike Schaefer.
Is Kentucky.
Continual lies. Why would he lie if he had just a simple, mistaken conduct? Apparently, the car was stolen, or hers, and I was, that's why I was worried. That's why I was lying. That's why I was lying. The car certainly was stolen. What he is lying for is to cover up his fundamental role in this conspiracy to kill Crystal.
It's okay. It's still early in the day. Don't worry. Oh. Girl. No, thank you.
Let's go through a couple of my things here.
I did not know that's where bourbon came from.
He lied to the FBI.
Where you know? Well, the word.
When he said he never touched that car. Well, he obviously touched the car. And so when you are looking at the evidence in this case, is there some gaps? We would like to know more. But what we know, without a doubt, by his own words and actions and where he was that during this awful, evil period of time when this young lady lost her life. We know from his words and from that evidence, he was an essential partner in Brooks' house plan to kill this young lady. His words tell you that. Where he was and the acts that he took tell you that. His attempts to lie and lie tell you that. A lot of what you saw in him on the stand today was much like his mama told him. She can tell he lies by doing the kinds of behavior you all saw him doing. Brooks' house needed an important partner to take care of that car. And he needed someone to agree to kill her.
Well, depends.
Steve Lawson was involved in both of those.
Oh,
By his own admission. He made and has tried, and his very competent counsel has tried to lessen it, to make it less serious. It really was just, he put that car seat of hers up some because I didn't want it to come out that Joey stole the car.
that'll do it.
That's ridiculous. He brought it up there as a way to create the illusion that the last person sitting in that car was Crystal Rogers. The only person who would do that night is a person who is keeping that conspiracy alive and protected. And that's why he fiddled with and put that seat up so that it would create an illusion when the police were there. That Crystal may have been the last one driving since the seats pulled way up. That's what he wanted. It was a part of his continued lies, cover up in this particular case. Stacy Kramer came in, thinks a former girlfriend for a while in 19 or thereabouts, worked with Brooke Houck, and she saw something very odd about the communication going on shortly before this crime occurred, this awful crime. And she told you that what Steve, over some conversations they had about this, Stacy said, and he was talking with Brooks Houck right before this, Steve was, and she was talking to him and asking, what's this about? And he said, I was talking to him about a girl I have to take care of that's on meth, and there are children involved. And Stacy asked if it was a family member, and he said no. He said, this is what I was talking to Brooks about. He was talking to Brooks at that time. He was talking to Brooks because Brooks is telling him,
I had to go get
I need her gone and I need somebody to do it for me. It scared Stacy what she saw and what she heard from Steve. And she told you in the grand jury, and you have it in your evidence, that she wrote John Snow and them, I need to talk to you. I got something that bothers me a lot. And she had good reason to be scared and good reason to be fearful of what happened. There are cases, sometimes perfect, but most are not. We're all human beings. Sometimes mistakes are made. Sometimes we can't find all that we want and need. We found, in this case,
Let's wrap it up.
all the evidence from the mouths and actions of Steve Lawson that point in one single direction. And that is, he partnered up intentionally and at the request of Brooks Houck to assist in that undertaking, that evil undertaking on the summer of July the 3rd in the evening hours. And why would Steve Lawson, you may ask yourself, why would he do that? Why would he partner up on this evil enterprise? You heard it in his testimony before the grand jury. Brooks told him, you heard it yesterday in the grand jury. Did you get paid for this endeavor? He promised me all the drywall business.
But he didn't get no drywall business. And I didn't hear him say that when he took the stand. Did you guys? Because I was trying to listen for that.
That's why he did it. He saw at the end of this dark tunnel the opportunity to make a lot of money.
I don't know.
A lot of construction goes on in Bardstown. A lot of our towns here in Kentucky,
I feel like they have even
thank God,
less.
are doing well. Business is going, and he was going to make a lot of money. That was his 30 pieces of silver. Let me go over a couple things I mentioned in my, and then I'll finish up here. And you have the instructions in front of you. The proof in this case, all the elements are there for he violated the conspiracy to commit murder. The plan was to murder. He knew it was to murder. We don't have to prove a murder happened, but we have a lot of proof they planned and took action. Part of that action was the very steps he took to get rid of that car, or attempt to get rid of it, with his son Joey. Did the defendant act with the intent to promote or facilitate the murder of Crystal Rogers? When he got in that car and dropped Joey off to take Crystal's car, the God knows where that plan was going to be, but it was to take it away, gone, along with her. Create an illusion. Did he agree to aid Brooks Houck in the planning of this murder? Yes, they talked about it. He tells you in the grand jury we talked about it. And what he was going to get out of this for carrying it out. His own words. And that pursuant to and in furtherance of the agreement, the defendant transported Joey Lawson to the vehicle of Crystal Rogers with the purpose of relocating that vehicle. That's right in his own words. Today and on September the 23rd. That's the very embodiment of the elements that we are required to prove as for the people of the Commonwealth, prosecutors like myself and my colleagues. I agree with Mr. Wolf. We owe our obligations to that responsibility to bring to you the evidence that you can review and decide upon. What you have heard over the last 3 days, and the evidence in this case is conduct and words, that's exactly what he did with intent to promote or facilitate that murder. He took charge of that car he enjoyed. And the plan was, get it out of here. That's common sense. That's the God-given common sense that we need to decide what happened here. The facilitation to commit murder is a lesser included, and that you can consider those elements are there as well. But that's a lesser. You only go to that
I do
if you're
like
unable
it.
to decide the first one, 3A. Then you can go to 3B.
Okay.
And that's just part of it. You got it. The defendant agreed to assist in moving Crystal Rogers' vehicle while knowingly providing Brooks' house with the means and opportunity to kill Crystal Rogers. My God, that's exactly that. The plan was to kill. He knew it was to kill. He even tried to get Girdley to do it. He couldn't, but he knew that was the plan. And I'm on. I'm going to get all these jobs when it's over. I'm going to be rich. The tampering, my colleague, Mr. Wolf, has already told you there's no dispute on that. You know, Mr. Wolf and I have been around. I think I first met him. He didn't have gray hair at that time. We've been around, and he's a good lawyer. And he's told you what all of us do. We're deeply grateful to the time that you all spend. Our Constitution is the best, and I think that's one thing Mr. Wolf and I agree on, and we respect it. Both this problem. In fact, we embrace it, and we embrace what you bring to our communities here to try to resolve these disputes. They're critical to all of us, and I would be, remiss if I didn't, like Mr. Wolf, say thank you for the time and all the attention you've given in the last 3 or 4 days. Thank you all. Thank you, Judge.
Good point. Ladies and gentlemen, the jury, just be seated here for a second here. What we're going to be doing next is selecting the 3 alternates who will be excused on this case. Whoever that is, I don't want you to leave mad at us because you've been up here for 4 days. I want you to understand how important it was to have you here. I've had trials where I've lost 2 jurors on the very first day. People get sick, things happen in people's families. So if I didn't have something like that happen, I didn't have enough. I'd have to declare a mistrial and do everything over. So that's why we had 3 alternates in place. Want to make sure everybody's okay serving, nobody's sick or been unable to pay attention because of something going on in their lives. Everybody okay? Okay. I'm going to have the clerk come in, and you'll be randomly selected when they do the computer here who the 3 alternates are on this case.
Okay. I have to line up all of our videos for after this. So we got to switch like 3 times. I agree.
The alternates are. I'm going to have the clerks.
I agree.
The sheriff's office escort you out to your vehicle to make sure you get out of here. If anybody from the media wants to talk to you, that's your choice whether you talk or not. Okay.
When they say like common sense so many times like that, it's kind of like with Steve with his, I'm just being honest. I'm just, telling the truth. It's the same kind of thing. It's like you're using that too much. It's suspicious. Because I'll be honest, if you do use your common sense in this, it's not as clear cut as one would think. Better yet, define common sense. Oof. Bar seems low. It is condescending, right? Right? I know that they get to like relate to, lay people, but it's like,
Got the three names. Who are the three names?
Tanissa Carr, Austin Duvall, and Samuel Thomas.
I'm sorry, guys.
Maybe put in your notebooks in your call.
Okay. Those three jurors, on behalf of the court system, we sincerely appreciate your service. I know you're not well paid for this, and we certainly do appreciate
Get
it.
$12 a day, $12.50 a day.
Somebody from the sheriff's office will escort you out.
Outrageous.
And if I could have the bailiff who will be in charge of the jury come forward, so I can give you your oath. Do you swear or affirm that you will take charge of the jury, that you will not allow them to separate, that you will not allow anyone to communicate with them about the case, and you will not attempt to do so yourselves? Thank you, guys. I'm going to give you all the original instructions. We'll also send in the exhibits. The pizza should be back there. Is it here yet?
Oh, pizza
Yet?
party.
Okay, it should be there. So at this time, you may go with the bailiff. Knock on the door when you're ready.
All right. Little simmy.
Okay. One thing I want to say before we take a break, everybody can be seated for a second here. One thing that's very important to
That's
me
what we said earlier.
is that this jury is shown respect. No matter what this decision is, I'm telling everybody right now, this jury is to be treated respectfully. If anybody has any type of outburst, we're going to have a problem. These people have been up here paying as much attention as they can, and they're being paid $12.50 a day. So it's very important to me that we treat these jurors respectfully no matter what occurs. So that's all I want to leave you with. Before we take a lunch break. I'm not going to take any return until 1:30. That gives everybody an opportunity to go somewhere and eat. After 1:30, whenever the jury's ready, we'll have them brought back.
I'm sorry. That's just a joke for what we ask of civilians in this case. Like, come on. We can't bump that up to like, I don't know, $40 a day.
You see counsel at the bench. We just have a question, I believe, is the issue.
Right?
I just wanted to see how
everyone is guilty. That's
typically true. I received a question from the jury apparently. Typically, I just have the bailiff bring the question in without the jury coming back. Are you all fine with that? Yeah, we usually do that. We have the questions. Thank you. Let's see here. What is the difference between 3AB? Let's see, where it says agreed to aid, and then 3BB. 3BB.
Sure, they don't care.
It says agreed to assist in moving the vehicle.
Sometimes they do, but
I don't think we can answer
Yeah,
that.
I think I'm.
So use the plain meaning of those words.
I think I'll just write on there. The court is not allowed to give any answer other than
Oh,
to follow
crazy.
the meaning of the words and the instructions.
I love it.
That's suitable with everybody.
Yes.
Sounds good.
Okay, let me write it down here before we leave. Make sure I got the right thing. I don't want my rephrasing. Okay. The court
It's cute. They just write notes back and forth.
is not allowed to answer the question except to ask the jury
Oh, and we love you, Julie.
to follow
Juju.
the plain meaning
Whoever you are today. YouTube decides.
of those words. Everybody okay with that?
Yes, sir.
Okay.
Okay with that?
Dude, that's like
Sign that.
bonking him on the head.
And what I'm going to do is I'm going to have, before it goes back in, Fran, if you'll make a copy in case for some reason it didn't come back, that'll be part of the record. All right, anything else we need to take up at this time?
It's on our part.
I'll go write a decision then while I'm waiting.
We've had that happen. The note didn't come back.
Do what?
It's so weird. I know.
Couldn't find the note in the record later. Yeah, we've always made a copy.
Okay. Looks like we got some sort of verdict. I'm going to run to the bathroom real quick while the jury comes in. Oh, say something.
You're not classy enough for our neighborhood.
Oh. Wait.
Fix the beeping.
All 12 jurors have returned to the courtroom. Everyone may be seated. The bailiff indicated that he had a knock at the door that you all had reached a verdict. Is that correct?
Yes, sir, Your Honor.
Sir, are you the foreperson?
Yes.
What is your name, sir?
I am Patrick Hart.
Thank you, Mr. Hart. You hand that to the bailiff. He'll bring it to me.
Yes.
As the court has already warned everybody, there's to be no outbursts when the court reads the verdict form in this case. Okay, this time I need the defendant and counsel to please stand. The verdict form reads as follows. On instruction number 3, it says, "We, the jury, find the defendant guilty of conspiracy to commit murder under instruction number 3A." Under verdict form number 4, it says, "We, the jury, find the defendant guilty of tampering with physical evidence under instruction number 4." Counsel, would you like for the court to poll the jury at this time?
Yes.
Okay. Ladies and gentlemen, the jury, and you all may be seated, thank you. I am going to read out your name, and I need for you to say yes or no as to whether you agree with this verdict. Jamie Lynn Bailey.
Agreed.
Riley.
You know what?
Page
We don't
Thomas.
need to hear the jurors' actual names. I'm going to skip that because I don't really think that's super appropriate. So sorry, Elbow, just got home and he's deciding to have a whole conversation right now on the phone. So that's fine. So let me skip that. Okay. So yeah. So in Kentucky, they do this fun thing where the jury recommends a sentence. So we're going to hear another brief hearing. And we got like 2 or 3 witnesses. So let's see what they have to say, okay?
Mr. Hogan would come forward, please. Mr. Hogan, I need you to raise your right hand. Do you swear or affirm the testimony you're about to give?
Oh, this is the
will be
same guy
truth,
from
the whole truth, and nothing but
the
the
trial.
truth? Thank you, sir. If you have a seat over there, please sit as close to the microphone as you can, and please answer all questions asked of you.
Mr. Hogan, would you please introduce yourself, ladies and gentlemen of the jury?
Brian Hogan, Probation and Parole Officer, District 3, Bowling Green, Kentucky.
Okay, and you cover several counties, right, in your district?
I do, sir.
Okay, and part of your job with probation and parole is you're under Department of Corrections, is that correct?
I've never heard them
You
be
all
called by
determine
their
parole
names
eligibility, is
when
that
doing
correct?
that either.
We do.
So it's
Okay,
kind of weird.
I want to talk a little bit about what the jury is convicted the defendant of a Class D felony tampering with physical evidence,
Correct.
as well as a Class B felony conspiracy to commit murder. Is that correct?
Correct.
All right. And I'm going to ask permission to lead a little bit, if it's okay with the judge and counsel, to get us. Mr. Hogan, a Class D felony carries a penalty of 1 to 5 years. Is that correct?
That's correct.
And pro eligibility, we let the jury know what pro eligibility is on a Class D felony.
15%.
Okay, so on a Class D felony, an individual would come up for parole. Doesn't mean they get parole, but they would come up for parole after service of 15% of that sentence.
Correct. Minus any applicable jail credit.
Minus any applicable
15%.
jail credits.
Oh, wow.
And
Okay.
on conspiracy to commit murder, that's a Class B felony. Is that correct?
Correct.
With a sentencing range of 10 to 20 years. Correct. And what's the pro eligibility on that?
85%.
85%. So an individual who is sentenced under that would have to serve whatever term of years they get, would have to serve 85% of that, correct?
Before being eligible for parole. Yes.
All right. And one of the things the jury could consider or make a recommendation to the court as to whether or not the sentence on the conspiracy to commit murder and the sentence on the tampering with physical evidence could run concurrent or consecutive. Is that correct?
Yes.
And that's terms we don't use every day, and it's a legal term, correct?
Yes, sir.
And concurrent means that the two sentences, the tampering and the conspiracy, would run together as one.
Correct.
So if you gave a 10-year sentence and a 5-year sentence, it would be just a 10-year sentence.
Correct.
If you gave a 20-year sentence and a 5-year sentence or a 1-year sentence, it would just be a 20-year sentence.
Correct.
There's also, the jury will be able to make a recommendation that it run consecutive, correct? And that would mean that they would be added together, correct? But it would be just one term. The person wouldn't have to serve the 10 or 20 years and then start serving the 5 years. It would just be a one term of, let's say, a number of years. So it would be like 21 or 25 years.
Correct.
Okay. And
This is
the
the
parole eligibility, I want to talk about the
guy that
difference
works
herein, though, is
at the
that
jail or
one's
something.
considered a violent offense, correct?
That's correct.
The conspiracy to commit murder.
Yes, sir.
All right. So anytime, because it's an 85% serve, anytime giving on the tampering would automatically be concurrent with that time. Is that correct?
Correct.
Because that time would, and I know this is not a legal term, would eat that up. Is that fair to say?
Correct.
So whatever term they give them on conspiracy murder would be the total sentence. Is that correct? Okay, as far as
parole eligibility.
right. And because this is a violent offense under conspiracy to commit murder, they would have to serve 85% of whatever they got.
Correct.
Correct. And then they would become parole eligible. Is that correct?
Yes.
Now they could serve the whole term.
They could.
All right. So on a 10-year sentence, do you have the certified copy of parole eligibility with you?
I do.
On a 10-year sentence on conspiracy to commit murder, the defendant would become eligible in 8.5 years. Is that correct?
Yes, sir.
All right. Could you tell the jury on a 12-year sentence how long an individual would have to serve?
10 years, 2 months.
And on a 14-year sentence?
11 years, 11 months.
A 16-year sentence?
13 years, 7 months.
An 18-year sentence?
15 years, 4 months.
Sentence math
And
is
a 20-year
wild.
sentence?
17 years.
17 years. So no matter what, if an individual is given 20-year sentence, they will be eligible for parole after 17 years of service, correct?
Yes, minus the applicable jail credit, correct.
Minus applicable credit. What do you mean by that?
Any days that the defendant would have served incarcerated previous to the sentencing.
So if the defendant had served time awaiting trial, they would get credit for that. Is that correct? Okay. So if a jury imposed a 10-year sentence, it would be an 8.5-year sentence.
Correct.
If they imposed a 20-year sentence, it would be a 17-year sentence.
Correct.
And while they give
Not
time on the tampering, 1 to 5 years,
Wait, you said a 17-year sentence, 17-year parole eligibility.
17-year parole eligibility. I apologize.
Yes,
It would be a 20-year sentence, but a 17-year parole eligibility.
Correct.
Thanks for correcting me on that. The tampering charge, parole eligibility wise, would be the same. Is that correct?
No, it's 15% on tampering.
But it would be,
Correct, yes.
yeah, it would be, they would
Yes.
already be parole eligible on the tampering,
Correct.
whether they get a 10-year or 20-year sentence.
Correct.
Is that correct?
Absolutely, yes.
Okay. Did I not, is there anything else I should be explaining on that?
I don't think so.
You don't think so? Okay, Judge, I don't have any further questions.
Sometimes jail days will count as 2 days.
Questions?
Sometimes if you
Maybe
take
it's with the
classes,
speak
it
out
takes
excuse.
off time.
Mayor.
Your
Different
balance,
states
you
do
may go.
different
Call your
things,
next
but it is
witness.
complicated.
Before you're on.
Oh, Tori Rogers. This is Crystal's
And if you'll
oldest
come forward,
daughter. I
raise your
think
right hand for me.
Tori's the oldest one.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? If you'll have a seat right over there, please sit as close to the microphone as you can. Please answer all questions asked of you.
All right, we gotta get through this, okay? Go ahead and introduce yourself, ladies and gentlemen.
My name is Tori Rogers.
And tell me a little about yourself, Tori.
I'm 21. Crystal is my mom.
If she's not the oldest.
It's okay. So I'm gonna ask you some questions, okay? Crystal's your mom, right? How old were you when the last time you seen your mom?
I was 11.
Okay. And you have something big coming up, don't you?
Yeah, I'm getting married
Okay. And where do you live?
in Bardstown.
In Bardstown. And after your mom went missing, where'd you live?
With my mama.
With your mama? Is that Sherry?
Yes.
Okay. Did Sherry take care of you all?
Yes.
Okay. And tell me about your brothers and sisters.
I have 2 sisters and 2 brothers, and my 2 sisters and my 1 brother live with me, and with my mama.
Okay. And the one brother that didn't live with you is Eli. Is
Yes.
that correct?
Yeah.
And that was Brooks and Crystal's
Yes.
child. Is that correct?
Yes.
Okay. And he lived with his father. Is that correct?
Yes.
Okay. So your mama raised you all after your mom went missing. Is that correct?
Yes.
Okay. So tell me a little bit about your mom.
She's the kind of person that whenever she smiled, everybody else smiled. She was so funny, and she was really the best mom ever.
I think she looks a lot like Crystal.
Did y'all spend a lot of time together?
Yeah.
Did y'all grow up together?
Yes.
Your brothers and sisters?
Yeah.
Did y'all stay in the same house?
All of them, Ashley. Yeah.
All of them but Ashley? And Ashley lived with Mama, right?
Yes.
Okay. And tell me, you're gonna have to talk for everybody, okay?
Okay.
All right, I want you to tell me how this has affected your family.
We've had to go through all our big milestones without our mom. It's been really hard.
She sounds
won't
like
get
Sherry,
to see
too.
me get married. She didn't get to see my sister get married or have kids. She won't get to meet my kids or any of my siblings' kids.
Well, she went, when this first happened, she went missing, right?
Yeah.
How long had you held out hope that you were gonna find her?
I still think we'll find her. Maybe not the way we want to, but I think we will.
Did y'all look for her?
Yes.
Is there anything you want to tell the jury that just how this has affected you or your family?
It's not gotten easier. It's been so hard every day.
Have you been there for your brothers and sisters?
Yeah.
You're the oldest one, right? Ashley's the oldest one,
Yeah.
right?
Yeah.
Have you and Ashley been there for your brothers and sisters?
Yes.
Okay, y'all are close, right?
Yes.
Okay, do you have anything else you want to tell the jury?
No.
Okay. No further questions.
Any cross? May this witness be validly excused? You're validly excused. You may go.
She sounds a lot like Sherry. Her voice does.
Mr. Wolf, any witnesses you wish to call?
Barbara Coulter.
Yeah, she has
Barbara Coulter.
Ashley, Kaylee, Tori,
Ms.
Trenton,
Coulter, if you'll come
and
forward,
then
please.
Eli. I get the order of the girls mixed up, but I'm pretty sure it's Ashley, then Kaylee, then Tori.
Ms. Coulter, Ms. Coulter.
And the
could you
girls
raise
are
your right
all
hand again for me.
adults.
Right.
I don't.
Do you swear or
No,
affirm the
Trent would
testimony
be that.
you're about to give will be the truth, the whole truth, and nothing but the truth? You may have a seat right there. Thank you.
I wonder if that's where you've been, slaving away, making your nightclub dollhouse.
Ms.
I
Coulter,
love
thanks
it.
for coming back. You need that down? obviously the jury has heard from you already, but can you tell them again who you are?
My name is Barbara Coulter.
Okay, and what's your relationship to Steve?
Steve Lawson is my son.
Okay, and how old is Steve?
He'll be 55 in September.
And I assume you've been a part of his life, his entire life?
Yes.
Okay, can you just tell the jurors a little bit about Steve? Let's talk about him growing up, what he did when he grew up, what he liked, kind of things that he enjoyed.
Well, we lived on a farm pretty much his whole life, and that's what he loved to do. And he was good at it. We raised tobacco, we did corn, cattle. He was good at it. And when he got married, he went to his own life with his wife, and they had a child, Joey. And by that time, I had moved to Louisville. So I lived in Louisville for almost 15 years. And when all of this started, I knew nothing about it except the drop in the water. Then in October of 2015, I moved back to Bardstown. I was still working in Louisville as a nurse, but I moved back to Bardstown. And at that time, I started hearing more stuff about Crystal Rogers. And the more I heard about it, I would watch the documentaries on it. And even all through all of that, I had no idea my son was involved in any of it, And I kept thinking, there's no way that people could do stuff like that and not have some kind of empathy or something. And I want to apologize to the ballots, especially Sherry. Ever since I've been back to Bardstown, I've watched her dig and scratch and pull and try to find an answer. And if I was the mama that was happening to, I'd do the same thing. She's gone through a lot. And I empathize with her. And she has my compassion because there's not a mother at all that would not have done what she's done. But then I look at Stephen and I'm questioning. Because I didn't raise my son to be involved in anything like this. And he's talked to me. And I mean, I've got really ugly with him because I raised my boys by themselves. Their dad was never around. And when I think of him being involved in anything like this, it just blows me away. I can't think of him doing anything like that. Now, I know that he has publicly said that he moved the car. I mean, when he got joined, did stuff to the car, right?
Sure.
I understand that. Well, I don't understand it. Number one, I don't know why he even got involved in it. That's when I get angry. I don't know why my son even touched the car or my grandson touched the car. I have a problem with that. And I know I learned a long time from my grandmother. There's two laws in this world we have to follow. And that's the law of God and the law of the land. And if you don't follow those laws, there's going to be consequences. So I know with whatever Stevie has done in this case, he's going to have a consequence. But I want people to know that that was a person, he was back years ago. And he did change. And like I said, I wasn't around my children a lot after they grew up. They had their own families. They moved away. They did their own things.
You look good.
I was in Louisville. They'd come down for Christmas, Easter, Thanksgiving, family stuff. But everybody had their own jobs and did their own thing. But Stephen was a good man. He was a hardworking man. He took care of his family. He done what needed to be done. So, I know that with this being said and done, that he has to have some kind of justice. But I just hope that people can realize if you're a mother, you know your children, and somewhere he did go wrong. But I know that he's a good man. He's a good person. And I just, that's all I can say.
The jurors are going to have to go back now and decide on a punishment for him. They're going to have to determine how many years he spends in prison. Are you aware of that?
Yes, I am.
Okay. On the low end, it would be 10 years. Okay. On the high end, it'd be 25 years.
Yes.
Okay. What would you like to say to these jurors before they go and deliberate about that?
I want you to set your heart and know whatever the decision that you make is the right decision for you. You know, it's up to each individual how you feel and what you want to do. But know that when you make that decision, that's a decision you have to live with the rest of your life. And whether it's a big one or a little one, know that you're the ones that are going to make that decision. And I just pray that you'll do the right thing, because I prayed about it for months. And I just pray that God will take care of not only you all, but the Ballards and my son and anybody else that's involved in this. Everybody needs to come to justice.
That's tough.
Thank you.
Any cross?
No, sir.
But what a good lady, though.
Thank you, ma'am. You're excused. Mr. Wolf, any other witnesses you wish to?
One second, Your Honor.
Randy?
I know I'm about to be starting my 4th childhood and next month. Ooh, a big 4-0.
Judge, no additional witnesses.
No additional witnesses. Okay, let me see counsel at the bench.
She seems like a lovely lady.
There's no surprises in that. Those are pretty standard. Randy, if you could give one to Shane to see if he has any objection to anything in that.
I wonder if the news cut the lawyer fight.
I gotta get paper.
Or it was exaggerated before this came out, but I never really saw them get too heated.
But this is right.
Yes, I need to chance. Need to change facilitation conspiracy on the person.
Saw that.
Anything else?
I haven't seen it.
You don't have the last page.
Yeah.
She went up. She can put on. She's good for you. They're good. Randy, if you can make that change on the first page. Looks good. Everything okay? Yes, sir. Any objections to it?
No, I didn't see any objections other than what you already noted.
That's right. That's right. Thank you all.
Hi, it's time for midday mimosas. I think so.
Randy, whenever you print that up, you give it to me.
That is.
Here in a second, I'm going to read you the instructions for the sentencing phase, and then we'll have closings by counsel.
Okay. We're almost there, guys. Almost there.
They read as follows. The jury is instructed as follows. It is now your duty to determine the punishment to be imposed upon the defendant. You have tried the defendant and have returned a verdict finding him guilty of conspiracy to commit murder and tampering with physical evidence. From the evidence placed before you in that trial, you are acquainted with the facts and circumstances of the crimes themselves. You have now received additional evidence from which you shall determine whether there are facts and circumstances bearing upon the question of punishment. In your deliberations, you may consider the evidence presented to you in the first phase of the trial, as well as the evidence presented to you in the second phase. Instruction number 1. Pursuant to the verdict returned by you, finding the defendant guilty of conspiracy to commit murder under instruction number 3A of the guilt phase.
I would say they didn't prove
proceeding,
conspiracy
and under the
again
evidence
to
presented
me.
you in
But
both stages of this trial proceeding, you shall fix his
I'm a
punishment
jury,
and confinement in the penitentiary for not less than 10 years nor more than 20 years in your discretion. Instruction number 2. Pursuant to the verdict returned by you, finding the defendant guilty of tampering with physical evidence under instruction number 4 of the guilt phase proceeding, and under the evidence presented to you in both stages of this trial proceeding, you shall fix his punishment at confinement in the penitentiary for not less than 1 year, nor more than 5, in your discretion. Instruction number 3, the verdict of the jury must be unanimous, and it must be signed by one of you as foreperson. You may use the verdict form below for writing your verdict. There will be attached a verdict form. Number 1 says, we, the jury, fix the defendant's punishment for conspiracy to commit murder under instruction number 3A at confinement in the penitentiary for a term of, and you will fill in the number of years, and the foreperson would sign it. The next one says, we, the jury, fix the defendant's punishment for tampering with physical evidence under instruction number 4 at confinement in the penitentiary for a term of, and there's a blank to fill in for years, and the foreperson would sign. Underneath that, it says, now you are to recommend whether the above sentences are to be served concurrently or consecutively or some combination thereof. Concurrently means running together one with the other. Consecutively means running one after the other. Then it says, we, the jury, recommend that the above sentences be served, and you would either write in concurrently or consecutively for however many years that is. There's a signature line for the foreperson. So at this time, Mr. Wolf, do you wish to give any closing remarks?
I do.
Proceed when you're ready.
Thank you, sir.
May it please the court, counsel, Mr. Lawson, Mr. Butler.
Oh, I see a big poster board over there. Did we use that already?
Never a good spot to be in as a defendant and or a defense attorney, right? I came up here and I asked you, told you what I thought the evidence showed, and obviously there was something that I didn't see that you folks saw. So I just want to start by letting you know that everything that we did was based on our belief of what the evidence showed. We didn't do anything to try to deceive you. We didn't try to pull one over on you, and we respect your verdict. We respect what you saw, which was clearly something we didn't see. With that in mind, the second phase of this process now you have to determine, what do we do about it? You found him guilty, obviously, of what we conceded at the beginning, which was the tampering. And then you have also found him, of course, guilty of the higher charge. We had a conspiracy and we had facilitation. So you found him guilty of the conspiracy. And I know from the question that was asked by the jurors, there must have been some kind of discussion between the jurors about the difference between the conspiracy and the facilitation. And the words are difficult. They're difficult to wrangle with, right? It's not a simple thing. And with that, I don't know if I can be of any assistance to you at this point to answer any of the questions that you may have had back there. I really can't, okay? And what we need to do now, though, is figure out what do we do with Mr. Lawson. You folks have heard from basically from the person from probation and parole that the minimum amount that he can receive as far as time is concerned is 10 years at 85%. That's the minimum that he can receive. Think about that. That is 85%, which you heard already is 8.5 years. And 8.5 years, Steve Lawson, he's going to be in his early 60s at that point. Even if at a minimum he gets 8.5 years, he's going to be in his early 60s. I'd ask you to consider keeping that in mind when you decide how to sentence him at this point. It's difficult as an attorney, having tried to tell you what I thought was the facts and now asking you for mercy. It's a very difficult thing to do. And I want you to understand that. This is not comfortable for me. And I hope you don't think that anything I did during the trial was either offensive or was something that was done that you didn't like. That was definitely not my intention. And clearly not the intention of my client. He's the guy that's caught in the middle, right? He's kind of the guy that's caught in the middle of this whole process. And the question now becomes, what do we do? As you've heard, you've got a minimum of 10 on the conspiracy, a minimum of 1 on the tampering. I'm going to ask you, knowing that, of course, as his mother stated, it's completely within each of your individual discretion to determine, I'm going to ask you at this point to give him 10 years on the conspiracy and 1 year on the tampering. That's a total of 11 years. 11 years. That is a long time, a very long time. I think everybody here, well, let's see if anybody was older than me. Maybe not. 11 years is a long, long time. So, knowing what he has done and knowing, as you folks, you heard it, I don't think there's anybody in here that believes that he actually committed the murder. I don't think anybody here believes that because there was no evidence of that, right? We don't even know if there was a murder, right? But obviously, his involvement rises to the point of conspiracy. Knowing that he conspired and knowing that he did a tampering with physical evidence, please have it in your heart to do what his mother requested. Take mercy and pity on him. And please, we're going to ask you that you do 10 years on the conspiracy, 1 year on the tampering, and we're also going to ask that you run them concurrent. As you heard, what that means is it would be a total of 10 years. That would be a total of 10 years because the 1 year would run concurrent with the 10 years. Concurrent meaning at the same time, not overlapping. So please search your souls, search your hearts, go back, do what you think is appropriate. While we disagree with the verdict, we definitely respect it. And there's a difference between disagreeing and respecting. We respect each and every one of you. We respect your verdicts. We respect the time that you spent in this case, and just ask you to go back and have mercy on Mr. Lawson. Thank you.
Does the Commonwealth wish to give a closing?
Ladies and gentlemen, I want you to think about what you've heard of.
Uh-oh. It's going to be Shane's last hurrah. Buckle up.
Ladies and gentlemen, I want you to think about what you heard in this case. All right. And first of all, I want to say this much. Barbara Coulter is a fine person. Okay. She's one of the best people. I know Barbara. All right. It's hard on me. Okay. I know her personally. And it's hard on me because she's a good lady. But what our kids do, we can't be responsible for the rest of our life. And she's in that situation. And I want you to think about what you've heard. Okay. I want you to think about what you heard from this witness stand. Back in 2015, Steve Lawson was all in.
Make it as your ringer.
He was all in. He tells Stacy Cramner, I'm going to go take care of a woman with 5 kids. That's what me and Brooks are talking about. He was in on the plan. I'm not saying he murdered her, but he was part of the plan to murder. If you're part of the plan to murder, you're murdered. Think about what Elizabeth said. Think about what Elizabeth said. Do you think he cared? Do you think he showed compassion? Do you think he showed sympathy? Think about what Elizabeth said.
Yes.
She had murder on me.
Yes.
So I left her. She was going to tell the police. Do you think it was weighing on his conscience? Do you think it was weighing on his conscience when these people were out looking for their daughter, their mom, their sister, their relative? No. He sits up here and acts like he's going to own it. I'm owning it. I'm taking responsibility. I'm owning it. I'm a man. I'm a man. No, you're not a man. You're someone who led a family on for 10 years and could have helped them find their daughter, could have helped them get some closure in that 10 years. And he did. He let them suffer. He let us suffer. He stuck a knife in them and he twisted it over and he twisted it over and over again. Every time the police talk to him, do you know something? Can you help us? I don't know nothing. Nothing. Twist that knife a little more. Don't come in here now and ask for sympathy. You know when he owned it? When he got charged. Tuesday he owned it. When he got charged. When he finally got caught.
Tuesday.
He wasn't going to own it. He was going to let this family sit out here in agony for years. Don't take pity on him. Don't take mercy on him. He took those children's mother away from them. He knew it. He could have helped them, and he didn't help them. I'm asking you to give him every freaking thing you can give him. They deserve it. They deserve it for the agony they went. She's been gone 10 years next month, and he's known. Don't buy into sympathy. Don't for him. Don't. Give him everything you can. Give him everything you can, because he did not give a diddle about them.
A diddle.
Thank you.
Not a diddle, you guys.
Again, please.
It's just,
Raise your right hand
he's
again.
so over dramatic.
Do you
I mean,
swear or affirm that you'll take charge of the jury? You'll not allow
yes,
them to separate. You'll not allow anyone to
but like,
communicate with them about the case,
buddy.
and you'll not do so yourselves. Thank you, guys. I'll give you all the instructions. You all need to fill out the original instructions. When you're finished, knock on the door and let the bailiff know.
Good luck with that, Lori. Ugh. Okay, so I think, yeah, okay, so here's where you just switch over to this other video for like literally a whole 4 minutes. And then, because why would they cut off the sentencing for one channel? They did, because of course they did. So watch this for a few minutes, and then we have the actual sentencing by the judge, which is only like 20 minutes. We are almost done, folks. So let's make sure I got those. And
Raise your right hands again.
there we go.
Do you swear or affirm that you'll take charge of the jury? You'll not allow them to separate. You'll not allow anyone to communicate with them about the case, and you will not do so yourselves. Thank you, guys. I'll give you all the instructions. You all need to fill out the original instructions. When you're finished, knock on the door and let the bailiff know.
Hello, Lady in Gray. Have you ever heard of portals? Come on. Is it your first day? They'll have their lawyer meetings while she's asleep in the portal of their dreams. Okay, well, don't need to wait for them to leave.
Jury. Jurors have returned to the courtroom. Counsel waived the call.
Yes.
Right before we went on the record here, Mr. Hart came in as the poor person and has handed to the bailiff
As a poor person,
which I have now been provided. So at this time, the court is going to read the verdict form. As the court indicated, there's to be no outburst in the courtroom when that verdict form is read. Verdict form number 1 says, we, the jury, fix the defendant's punishment for conspiracy to commit murder under instruction number 3A at confinement in the penitentiary for a term of 17 years. 2, we, the jury, fix the defendant's punishment for tampering with physical evidence under instruction number 4 at confinement in the penitentiary for a term of 5 years. Under the next portion, the jury recommends the sentences be served concurrently for a total of 17 years. All 3 have been signed by the foreperson. Does counsel wish for the court to poll the jury on this question, on this verdict?
Yes, sir.
Okay. When I call your name, if you'll please state yes or no that you agree with this verdict.
remember this sound for a story I'm going to tell you after this over. This exact, I don't know why this is happening. I'm sorry I had to let my dogs in. Blame Zoe. It's all her fault.
Anything else you wish for me to take up with the jury?
No. No.
Ladies and gentlemen, the jury, that's going to complete your service on this case. I want to thank you on behalf of the court system.
Well, then I am not going to take that.
I know you all paid a lot of attention over there. You worked hard on the case, and we sincerely appreciate that. I wish it paid a lot more to be a juror, because I know you've been up here and making $12.50 a day, and we certainly appreciate everything you all have done.
I think
Make sure
so.
you leave your jury buttons up here and your notepads, and the bailiff will escort you on the way out. If the media wishes to talk to you, you have a right if you wish to talk to them. I always prefer juries don't. I always say what happens in Vegas stays in Vegas. What happens in the jury room stays in the jury room, but that's your all's decision, okay? So you may go with the bailiff. Thank you all.
Okay. So that ends that. Now, we're going to switch over to August 6th, which was just last week, where he was being sentenced by the judge, because this makes sense. I don't know why. I still don't understand why the jury gets to recommend a sentence. It's so stupid. I don't get it, but whatever. That's what they do. So, all right. So let's switch over to this one. And this is not very long, as I said. It looks to be a whole 20 minutes, if that, which is not surprising. And it looks like they're back in their Bardstown, Nelson County Courthouse, which is very nice looking. I think when we watch some of the arraignment.
At this time, let the record reflect, we're taking up Commonwealth of Kentucky versus Stephen Eugene Lawson. It's 23 CR 165 and 23 CR 371. The Commonwealth is represented in this matter today by Mr. and Ms. Young and Mr. Lasowski.
He looks different.
Also present is Mr. Lawson with counsel, Mr. Wolf and Mr. Buckler. By way of background, back on May 27th, this matter came before the court in Warren County for a jury trial.
I think he took that
On May
chair
30th, 2025, the jury returned a verdict finding the defendant guilty of conspiracy to commit murder and tampering with physical evidence. The jury recommended a sentence of 17 years for conspiracy to commit murder and 5 years for tampering with physical evidence.
Looks like he got new
The
glasses
court ordered
too.
a pre-sentence investigation report be prepared. And Mr. Wolf and Mr. Buckler, have you all had an opportunity to review that document with your client?
Judge, we have.
Are there any corrections that need to be made to that
From the
document?
Robin Hood
Two
movie.
minor, not really of consequence, but nonetheless,
Sorry.
let's just be visual here. The spelling of my last name,
What page are you at?
incorrect, page 1.
Okay,
Should be 2 Fs and no E.
2 Fs. Okay, I've made that change.
Thank you, sir. And then immediately following at the bottom of that, you see defense attorney, it says appointed or hired. As you know, we were appointed by DPA and we were not hired.
Yes, I will make that change also.
Those are the only two corrections, Your Honor.
Very good. And I know you all had filed a motion and the Commonwealth has filed a response to that motion. I believe it's a motion for new trial and judgment notwithstanding the verdict. Is there anything in addition you wish to submit in regard to that motion?
No, sir. Have to take it under submission.
Okay. Anything the defense or the Commonwealth wishes to respond other than what's already in writing?
No, sir, just what is in writing.
Okay. The court has reviewed the motion.
There's like
and the
nobody in
court,
there.
And the response. And the court is going to deny the motion. The court will enter a written order as to one portion of that. The rest of it, the court will rely upon the rulings that were placed on throughout the trial. As far as defense, do you all have any other motions or matters we need to consider prior to sentencing today?
No, sir.
Anything the Commonwealth wishes to present prior to sentencing today?
Yes, sir, just briefly, we do have two of the family members that would wish to speak.
Go ahead and call your first witness then.
Yes, sir, be Mr. Mike Ballard. Does he go to the podium?
Just come to the podium and I'll let him raise his right hand and then we'll have a seat over here at the witness stand. Mr. Ballard, you come right up there and raise your right hand for me. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You'll have a seat over there. Be careful. There is a step up when you get there. Just try to sit as close to the microphone as you can. And please answer any questions
this is
asked
her
of you.
uncle.
Mr.
I
Young, you
think
may
this
proceed
is-
when you're ready.
Tommy's brothers.
The family had talked, and you, self, and Brooke are going to be representatives and speak on behalf of them. Is there anything you would like to tell the court as it relates to sentencing and how this has affected your family?
Yes. You want me to go ahead and read what I've got?
Yes, sir, that's fine.
Okay. My name's Mike Ballard. I am Crystal's uncle. I'd like to start off by thanking the court for letting me speak here today. I'd like to also thank Tricia and Shane Young, the Commonwealth of Kentucky, State Police, FBI, John Snow, Nelson County Sheriff, anybody that had anything to do with Crystal's case. Without you all, we wouldn't be here today. Mr. Lawson, you've never met me, but I promise you, if I'm alive and able, you will see me again because I will be at your parole hearing when you come up for parole, and I will do everything I can to prevent you from getting parole because of what you've done. I know what kind of person you truly were when you had no one, and I mean no one at your trial to support or defend you. But the difference today, just look all around you. You see, we're all just not here for Crystal. We're here for you too. We came out to see the court pass final sentencing down to you today. Your last farewell before you go off to spend a very long time in prison, which I hope is the worst experience you can ever experience in a prison. Hopefully you'll spend the rest of your life there. I could stand up here and go on and on about what a worthless, despicable, pitiful, thoughtless, gutless person you are, but I really don't have to say what everyone already knows, but that's the life you chose. On July 3rd, 2015, I imagine Crystal woke up thinking it was just going to be another ordinary day for her, running errands, spending time with her kids, and getting them places they needed to be, like she did every day. Later that day, believing she was going on a special date with Brooks Howe, she was unaware that it would be the last day her children, her mother, her dad, Casey, and her sister, Brooke, would ever hear her voice or see her again. But you knew that. You knew all about that special date because you, Joey Lawson, your son, and Brooks Howe had a plan in place for the murder of Crystal Rogers and to dispose of her and her car. We all make choices in our life, and it looks like you made a lot of bad ones in yours. In July 2015, you made a choice to be a part of planning the murder of my niece, Crystal Rogers. You could have prevented all of this from happening if you'd just gone to the police and done the right thing. If you had done that, I believe Crystal would still be here today, and so would my brother, Tommy Ballard.
Tommy.
But no, you couldn't do that because you wanted the drywall works from Brooks Howe. And that's all this young lady's life was worth, and maybe just a little cash. A lot of people search for Crystal all the time, many searches, but nobody searched for her like her dad, Tommy Ballard. And you knew Tommy was a good man, and you knew he was out searching every day looking for his daughter. But you didn't care. It didn't make anything to you, didn't mean anything to you. And he searched for her every day, every night, until the day he died. And you knew it. You didn't say anything about it. You knew what happened. Again, you could have prevented it all. Crystal still would have been here, and I believe Tommy Ballard would have still been here. But you didn't care about anyone but yourself. You have no remorse, no feelings about it. I don't believe you're sorry about it. The only thing you're sorry about is getting caught and going to prison. You had many times you could have made the right choice, but never did. Crystal was a good person. She wasn't on drugs, and she certainly wasn't an alcoholic. She never did anything to anybody, and especially she never did anything to you. Crystal was a beautiful, loving mother of 5 children. She was a daughter, a sister, an aunt, a granddaughter, a niece, and never deserved for her life to end the way it did. We'll always remember that beautiful smile, and that's something nobody can ever take away from us. I hope the court gives you the maximum sentence possible, though it will never bring Crystal back and never be enough. Before I finish, I want to ask you to look at Crystal's family, look at her kids, look at Sherry. And don't you think they need to know where their mother's buried? so they can have peace and at least lay their mom to rest the way it should be done. And they deserve that. Wouldn't you want that if it was your mother or your daughter? Then you need to stand up, be a man, and do the right thing, because you're going to prison. But if you do one right thing in your life, this is the thing to do. Let them know where their mom is.
By the way, that cuts
I
and
don't know
pauses
that you were
is all
always this type of person.
TV problems.
Hopefully you weren't. Don't know when came about it, if you were, or what happened in your life. You say alcohol and drugs. Well, that may be so, but again, everybody makes choices in their life, and you made yours start it out to be the way it and end the way it is. Thank you for letting me speak. And, I don't know what else to say. It was very hard getting up here. Very hard to come up with what to say. I could go on, but I know they like to keep this short. But again, I just hope and pray and wish that you find it in your heart to let them know where them is. And again, I'd like to thank Shane, Young, and their team for moving the rock. That's all I got.
Is there any questions you wish to ask Mr. Wood?
What's that mean?
Thank you, Mr. Ballard. Call your next witness.
That's
Brooke
Enter Q about that time.
Brown.
Yeah, I remember
Yes, sir.
Connie and his family, they lost their sister many decades before to a husband that killed her.
Do
And
you swear or affirm
and their
the
brother
testimony you're about to
and their
give will be
niece.
the truth, the whole truth, and nothing but the truth?
I do.
You have a seat right over here.
Yeah, sorry, guys. I don't know why I keep doing this. But
That'll be fine.
Okay.
Brooke, go ahead and introduce yourself to the ladies and gentlemen of the jury.
I'm Brooke Braun.
And are you Crystal's sister?
I'm Crystal's sister.
Okay. And is there anything you would like to say or let the court know?
I do. Also, I want to thank everybody. And Steve, I just want to say you could have stopped this. You could have saved her life, and we wouldn't be here today. You had the chance to do the right thing, and you could have spoke up. You could have told the truth. My dad would still be here if you would have told him the day you met with him, and my brother. You knew what was happening. You had the power to stop it, but you stayed silent. Your silence took Crystal's life and my dad's. You chose evil, and evil never wins. Because of your choices, Crystal's children grew up without their mother. We all faced milestones without her. You took away her future for what? Money? All of Brooks' drywall jobs? Things you did not have and things you'll never have. You took away a life because of greed and selfishness. I hope every day you spend in prison reminds you of what you did and who you destroyed. I hope the weight of the truth sits heavy on you, and one day you'll have to answer for what you did. You may have helped take her life away, but you'll never take our memories. You'll never erase her name. Her story lives on, and we'll make sure that the world never forgets who Crystal was.
Mr. Wolf, any questions?
No, sir.
Thank you. Are you have a seat out in the gallery?
I imagine a lot more of them are going to have stuff to say with Brooks and Joey's sentencing next week.
Mr. Young, anything else you wish to present?
There is not, Your
Particularly mostly aimed at Brooks.
In a few minutes, the court will be pronouncing sentence in accordance with the jury's verdict. First, I do need to tell you, Mr. Lawson, you do have a right to appeal to a higher court, which would be the Kentucky Court of Appeals. If you cannot afford the cost of that appeal, I will appoint you a public defender to handle that appeal for you. The notice of appeal has to be filed within 30 days of the entry of the judgment. Counsel, is there any reason why final sentencing cannot be pronounced?
No, sir.
No, Your Honor.
At this time, in conformity with the jury's, it is the sentence of the court, Mr. Lawson be confined in a penal institution, therein to remain for a period of 17 years upon his conviction to conspiracy to commit murder, 5 years for tampering with physical evidence. It's a order of this court, all times shown together or concurrently, for a sentence of 17 years. Also, for the record, would note that at request for probation or discharge, the court believes he's totally precluded from asking that. But even if not, the court finds that to grant probation conditional discharge would unduly date the seriousness of this matter. I will be signing a judgment here today. After that judgment has been entered by the clerk's office, the clerk is going to send copies to both sides and then can be appealed if he wishes to do so.
Yes, sir.
Anything else we need to take up at this time, counsel?
I don't have to comment.
Nothing, but I'd like to approach on just administrative matter, but it has nothing.
Sure, come on.
So it won't.
That's all the usually the judges still like, say things. Oh God. Oh. This feed better not be like that Thursday with the in and out. Is it in and out for you guys? Because it is for me. Oh yeah. Oh, that concludes the hearing. That's all. Yeah, so he gets 17 years concurrently, ran with 5 years of for the tampering. I can't remember for Joey and Brooks. The jury recommended life for murder, and 5 years max for tampering with evidence as well. And then I think for Joey, it was the same as his dad. I don't entirely remember because, to be honest, I kind of always forget about Joey. But they, as I said, are being sentenced this coming Thursday, not tomorrow's Thursday, not that Thursday. Let me fix that. Next Thursday, August 21st at, I think, 1 o'clock Eastern time. So Court TV, as you see, did the sentencing for that. So I very much expect them to also cover Brooks and Joseph's, considering Brooks is the bigger deal out of all of them. Excuse me. So we will definitely be watching that, hopefully live, but we'll just have to see how that happens. Now, our next case is the Donna Adelson case. Now, if you missed this morning when I talked about it, next week starts jury selection for her trial. And I'm not sure exactly which day, but I'm going to do kind of like a catch up for everybody who may not know Donna Adelson or the Adelsons, and kind of briefly catch you up. I'm not going to do a super deep dive because I'm sure a lot will come out in trial to fill in your gaps there, but at least give you guys a who's who and that whole conspiracy to commit murder, which has a lot more evidence than this one, but whatever. Now, jury selection is supposed to be the 19th, 20th, and 21st. They said if they select a jury, they will do opening statements. So make sure you turn those notification bells on because we won't know when they are. And we'll be like, oh, we're going live in, an hour or whatever. But I do know that the state plans on beginning their case in chief on August 25th, no matter what. So next week for Couch Court, it's gonna be a little weird. We'll see how it goes, but I'll put something in the community tab so you guys know about that. Now, let me tell you about my plans for tomorrow because there is no more Couch Court for this week. Tomorrow at 10 a.m. Eastern for our members only, I will be recording a tapings of a show that I'm planning on releasing in December. It's a true crime mini series. Hopefully a serious storytelling one. Me, I like to be pretty lighthearted, but I'm hoping to do something pretty, serious with this. And so I'll be recording that with you guys just so I'm not alone doing it. I don't even know if we'll use it for the final versions, but whatever. It'll be fun. So we're going to do that for a couple hours tomorrow. Then at 8 p.m. Eastern, pour yourself a glass of wine and let's take a deep dive into the Athens murders in Georgia. I will have the fantastic and lovely Cap'n joining me as a guest co-host tomorrow. Don't worry, Terry will be back next week. I know we all miss her, but I do have the lovely Cap'n. You've seen her before. She's been on. Now, you guys remember how I told you to remember that ringing sound that they, did when they were saying the jurors' names? So for like the last week, what is Day Wednesday? So at least 5 days, probably a week, in my neighborhood has been that piercing sound just like that, nonstop. Usually it's just like a long ring, but then sometimes it's like a beeping, like a flashing, sound. And it's been driving everyone in the neighborhood absolutely insane. And we finally figured out it was coming from one of the neighbors' house who have not been home. They're a whole different story, but they haven't been home. And so Elbow gets home from work and he's hearing it again because our one neighbor called us at 6 a.m, being like, do you know what this sound is? And we're like, no. So he finally goes over there. He's looking around for this sound because we know it's coming from that house. And these people, didn't want to deal with their smoke alarm. So they just threw it outside. If you knew the neighbors, you would see that this makes sense. They just 5 or 6 days ago just put it outside, didn't bother, taking the battery out or resetting it. No, holding our entire neighborhood hostage for days. I was this close to burning down their house. Just kidding. I wouldn't do that, but it was not fun. Did not like it. It was weird for ungodly amount of days. I've had to have the air conditioners on when we haven't even needed them, and the TV, so it would drown out that constant ring. It was awful. Is there smoke outside? Well, I think they're definitely smoking something over there. They're doing a lot of things over there, I think. But anyway, so yes, it's absolutely crazy. So Brandon finally found the smoke alarm and pressed the reset button, and guess what? It's done. And apparently they have a Ring camera too. And he's like, I stared straight into that thing, just giving it the angry eyes. As I pushed the button down, he's like, I can't wait till they come home so I can yell at them. Because we had a bit of a meeting with one of our neighbors last night, being like, I think we should call their landlord and tell them they need to get these people out of here. But yes, thank you all for joining us today. Oh, you know what? I forgot. Oh my gosh, I've been waiting for weeks to do this. I won't do it too loud because I know my mic is really good and picks up everything. But you guys, we wrapped up the Stephen Lawson case, and look, boop. Court is now adjourned for Steve Lawson. Boop. I'm going to do that on Thursday too with the sentencing. And by the way, if you guys didn't know this, the lovely Terry True Crime made this for me and gave it to me when she came up in July for our live show. Isn't that adorable and perfect? Oh, it's raining. Oh, that's nice. What was the other thing? I forget I was supposed to announce, but that's okay. Anyway, you guys, I will be back tomorrow for members only, 10 a.m. Stop by if you like this behind the scenes stuff. That is where I'll be. And then we'll be here again tomorrow night at 8 p.m. Eastern. And it's a good case, you guys. It is. I had never heard of it before, and it has some twists and turns. I put a lot of emoji reactions in Captain's notes, like, what? It's pretty good. So I look forward to doing that. Well, you guys, thank you so much, as always, for spending the day with me. And until next time, you know the drill. Go forth and be amazing. Bye, guys.